Good morning, everyone. I'd like to start off today by asking Representative Gregg to lead us in the Pledge of Allegiance. All rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'm going to begin the hearing on House Bill 1039. And I'm going to ask Representative Jody Nelson to come and introduce her bill. Good morning, Representative.
Good morning. Good morning, Madam Chairwoman, and good morning to my fellow committee members. For the record, my name is Jody Nelson. I represent Rockingham 13 in Derry. This bill came to me from one of my constituents I've known for a long time. She had an issue where when she was pregnant with their child, she and her partner agreed on the sharing and not sharing of certain images of their child on social media, and they split, and that agreement hasn't been honored. I have had discussions with other people about this over the years, and I find that it's more of a concern now just because of AI and also parents monetizing themselves and their children on social media. I prepared a statement, but my constituent did such an amazing job, and she's not going to be able to be here today. Instead of my testimony, I would like to read her testimony, and I have a written copy of it I will give to you after.
Thank you. Go ahead.
Thank you. I'm writing in support of this bill, which would allow parenting plans to include agreed upon provisions that govern the sharing of a child's image and personal information on social media. This legislation recognizes a reality that family law has not fully caught up to. A child's digital footprint can be just as permanent and harmful as any physical or legal record. When a child's photo, video, name, or personal details are posted online, they become part of a permanent digital record, one that the child did not choose and cannot meaningfully undo. That content can be copied, downloaded, altered, stored in data systems, and reused far beyond the original platform or audience. We now live in an era where artificial intelligence can replicate a person's face, voice, and identity from only a few publicly available images. What may appear harmless today can later be used for identity fraud, impersonation, deep fake exploitation, or long-term data profiling. A child whose digital history begins before they can speak may one day face financial, reputational, or psychological harm because of content they never consented to and cannot remove. This bill is not about limiting parents. It is about giving families the legal ability to protect their children by clearly defining expectations and boundaries in a parenting plan. In shared custody or high conflict situations, one parent's decision to post a child publicly can permanently expose that child without the other parent's knowledge or agreement. Without clear language in a parenting plan, courts and parents are left with no framework to resolve disputes, even when the child's safety or privacy is at risk. There's also a serious safety concern. Bad actors and online predators actively search social media for information about children. Names, locations, school logos, routines, and family schedules can often be inferred from posts that seem harmless. For someone with malicious intent, these details can be a roadmap. Children are not content. They are not digital assets. They are not branding tools. This bill does not mandate restrictions. It simply allows parents and courts to address this issue directly.
30 seconds.
When creating parenting plans, it gives families the option to set boundaries around what can be posted, require mutual consent, limit public sharing, or prohibit posting altogether if it's a safety concern. Thank you for your time and consideration.
Thank you very much. That was awesome.
Representative Gregg, you have a question?
Thank you,
Go
Madam
ahead.
Chair. I don't know why I just totally blanked. Thank you for taking my question. I appreciate this bill. I think it's something as we move into society and with AI taking pictures that it could be a problem. I just have a couple of questions. So, does this cover only the custodial parents posting or also like grandparents, new partners, friends? Like, what's the scope on this?
Thank you for my question, for your question. Um, it's in the parenting plan template, which is only going to cover the parents' agreement. So it would be only the parents unless both of them mutually agree to extend it.
Okay. And follow up.
Follow up?
And then also, is it retroactive? Like, can a parent say, okay, say now they're divorced? Can they say, like, I don't want you having any of those pictures up, or is it only going forward from the time the agreement happens?
Thank you for the question. That would be a decision that could be made during mediation, or if it's a high conflict case and it goes to court, then the judge would deem, what would be appropriate or what would not be appropriate. Thank you.
Representative Raymond.
Thank you, Madam Chair, and thank you. I have one question about the definition of social media, and whether or not, and what the definition would be in regards to this bill. I know RSA 18970 has a definition, but that is about schools creating social media accounts like LinkedIn accounts. And so I'm wondering if there is room to define it here, because does social media cover YouTube, or is it only like Facebook, Instagram? What about TikTok? I don't know the answer, and I worry about families getting into arguments.
Thank you for the question. Actually, if you could please give me one moment, I want to get a copy of the bill. I forgot to bring it over here. Is that okay, Madam Chairwoman? Oh,
Absolutely.
thank you. Thank you.
Just as a follow-up, I think it's an excellent idea. I just want to make sure we cover people in lots of situations.
Thank you. Well, if that's a problem, I would be happy to, I'd be happy to amend it. I did speak to a family law attorney and a mediator, and they didn't seem to have a problem with it. So, that was a good question.
Does anyone on the committee feel that there needs to be an amendment? Representative Pearson?
I think it would be very helpful as long as the words including but not limited to were in there to cover us. But yeah, spelling it out, I think, is helpful.
Okay. Okay. Just for full disclosure, Representative Petrino, who is our ranking member, and I were talking about possibly executing this today, but that's okay because we want to exec a bill that is perfection. So we'll wait until the amendment comes and consider the amendment before we exec this. And thank you for all of those who have discussed that amendment. Representative Levesque.
I just wanted to say that this is a really good bill, just because so many families right now are on social media. They're becoming influencers, and they're involving their children. Most of them will block out their faces or anything, which is smart to do, but I think that a lot of people, when it comes to divorces, will use their children's photos in a negative way, and a lot of abusers or a lot of child predators will target families that post photos of the children. And I think making sure that if someone has someone in their family that is a child predator, to not see those photos. And I think this is a good bill to have.
Representative Pearson.
Withdrawn, Madam Chairwoman.
Thank you, sir. Representative Georges.
Thank you, Madam Chair, and thank you very much for that bill. I love it because it's sometimes for the conflict for parents, for both of them. There is a one can take advantage for to do to public the child or something, and that is something can make very like what the people supposed to follow like the rule and the regulation. Thank you very much for that.
Representative Nelson, you had something to say?
Yes, thank you, and I agree with that. And also too, this is May. If both parents decide that they're fine with sharing, whatever they want to on social media, that's okay too. That's a decision that is made by the parents as long as it's in the best interest of the children. I just wanted to mention that too. This is not restrictive in any way.
Seeing no more questions, thank you.
Thank you, everybody.
Seeing no more pink cards for this bill, I'm going to close the hearing on House Bill 1039. I will give the clerk a few minutes to finish up, and we will have a few minutes to relax and digest what we've already heard before I open House Bill 1206 at 10:30. Welcome back, everyone. I'm going to now open the hearing on House Bill 1206, and I'm going to ask Representative Love to come forward and introduce his bill.
Thank you, Madam Chair and members of the committee. This is more or less just cleaning up language, making it and simplifying it. You know, we've heard many times in this committee that I believe the number is 74% of all family court litigation has at least one pro se litigant, and we should be simplifying things for them, if nothing else. And you know, notwithstanding any law to the contrary, can get awful confusing to someone with a high school diploma. And this just simplifies it and explains it better. I actually brought this forward for the Honorable Dan Itzy, and Dan hasn't made it here yet today, but you know, he's been trying to get this done for a while. Just plain simplifying, you know, simplifying the language. That's it. Thanks.
Thank you. Any questions? Representative Petrino.
Thank you very much, Madam Chairwoman, and thank you, Representative, for taking my question. So I'm hearing you say that this just simply cleans up the language, because when I looked at this, it doesn't seem like it changes anything. I mean, right, it says here that we're removing notwithstanding any law to the contrary,
Mm-hmm.
and we're replacing it with, and where no other special provisions have been made by law. It almost sounds to me, the way I read it, as the exact same thing. So I'm wondering why the change. I must be missing something.
Simplify. We're simplifying. Thanks for the question, by the way. We're simplifying for the person that doesn't have a law degree. You know, a lot of these constituents aren't even high school graduates. You know, and they can get confused by notwithstanding what the heck does that mean? You know, and when you know, when we have 74% of the litigants doing it pro se, I'd say a good percentage of them are in that, you know, high school graduate only, you know, classification, I guess. And let's simplify it. Let's make it so they don't have to have a lawyer. You know, we have liberty and justice for all, not just those that can afford a lawyer.
Representative Corson.
Thank you, Madam Chair, and thank you for being here to answer my question. So especially for litigants, especially pro se litigants, could you explain to me how this would change what they do or what would change?
Just a simplification. That's all. You know, it's taking a six syllable word and breaking it down to a 2-syllable word, and they both mean the same thing. Something like, you know, along those lines. You know, you can confuse people with big words. You can confuse people with legal language. You know, let's simplify.
Thank you.
Representative Gregg.
Thank you, Madam Chairwoman, and thank you for taking my question. I understand the desire to have simplification because I do know that our state has more pro se than others, but is it really wise to continue to, gosh, I don't know what word to say, but anyway, to, you know, make these more elementary when the law is a very complicated thing. That's why we do have lawyers and stuff. So is it really wise to continue to try to do things like this?
Wherever we can.
Representative Scher, did you have your hand up?
I did, but I withdraw my hand.
Thank you. Representative Pearson.
Thank you, Madam Chairwoman. Thank you, Representative, for taking my question. I have numbers of high school graduates on my staff, and would you think that what was said would sell them short? Because I think they would understand what's in law.
50% of all, thanks for the question. 50% of all high school graduates graduated at the bottom half of their class. Okay,
By definition.
Some are pretty bright. Okay, some not so bright. You can graduate with a 60% efficiency from high school. It's not very good. You know, so let's keep it simple wherever we can.
Thank you.
Thank you very much, Representative. Could you please fill out your pink card?
I'm
Thank
sorry,
you.
I forgot.
Having no other pink cards, we're going to take a few minutes break and we'll be back shortly. Representative Love has made a motion of OTP on House Bill 1206.
I'll
I-
second that.
Representative Petrino seconds that. Any discussion? Representative Levesque?
I just wanted to say that it is that you have to have a C average to pass any of the high school classes now. And it's on the New Hampshire Board of Education that they came out with the new curriculum where they have to have a C average in order to graduate or pass any of the classes. Or if they get anything below, they do have to retake those classes again.
Thank you. Representative Gregg?
Well, I think this is a small change. I want to just be very careful about not thinking that we need to go back through all legislation and laws and everything else to simplify. I think there is merit and there is a reason why we have lawyers, why legal standards are written the way they are. It is very complex. If people choose to be pro se, then that is their choice. So that's just part of that kind of asterisks that you have to be aware that you're going to have to look up things that maybe are difficult and stuff. But I do understand in this space, I think it's a small change and that's fine.
Thank you. Representative Pearson?
Thank you, Madam Chairwoman. I would underscore that by saying the guide that the Bar Association is working on to help pro se litigants will explain numbers more than whatever has been prepared thus far. And while I'm prepared to vote for this, I would not be prepared to vote for a steady stream of tweaking of language. Thank you.
Thank you, Representative. Any further discussion? Seeing none, will the clerk please call the roll?
Representative Pearson,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Representative Corzine is yes. Representative Moffett,
Yes.
Representative Petrino,
Yes.
Representative Scher,
Yes.
Representative Levesque,
Yes.
Representative Gregg, Representative Raymond, Representative Georges.
Yes.
11-0. Chairman DeSimone.
Thank you, Madam Clerk.
I
Chair
apologize.
votes yes.
Thank you. 12-0.
Representative Love will create the report. Representative Pearson, you have a question?
I have a suggestion that this goes on consent,
Oh my gracious, absolutely without.
having forgotten it most of my tenure as chairman. Yes.
And did you remember to call?
I did.
Without objection, this will go on consent. We will now close that hearing on 12:06. Yeah. I now will open the hearing on House Bill 1215 and ask Representative Kofalt to introduce his bill. Excuse me, Representative Scher and Representative Georges, you're not doing your jobs.
Uh-oh. 5-year penalty.
So the chair will. And
I'm
you're
still-
leaving me.
I'm still learning the mysterious ways of house
it out.
children and family law.
You know, it's pretty tough when you're leaving me to remind you.
No
And you-
comment.
And you are a defense lawyer too.
Thank you, Representative Kofalt, for changing that. I appreciate it.
Uh-huh.
And I say, I'm sorry, Madam Chair. I
For-
didn't remind.
And for that, Representative Kofalt, you now have 3 minutes.
Thank you, Madam Chair. So I will skip over, in the interest of time, I'll skip over some of what is in my written testimony. You will all be receiving that in an email. Let me begin by talking about autism and apraxia. We've all heard of autism. We know people with autism. You may not have heard the word apraxia before. Apraxia is a motor skills deficiency that leads to, among other things, the inability to speak. I have a friend whose daughter suffers from autism and apraxia. She laments the fact that for most of her life, people have thought that she was not very smart. She doesn't make eye contact. She does not have very many words that she can use. But in fact, she is as smart as anybody in this room and probably smarter than some of us. She is brilliant. She's interested in economics. She would like to pursue starting a nonprofit to help people to communicate. But she is one of many people who have experienced an absolute transformation in their lives through the use of spelling as a mode of communication. I know of a young man in Pennsylvania, Vincent Rinicella, who is a political blogger. He aspires to be the first non-speaking US senator. He writes a blog using sort of typing one letter at a time on a keyboard. Hari Srinivasan is one of the more prominent examples. He wrote the following: I was not expected to go to college. My educators put me on a path to get a certificate of completion from the special education system at age 22. After that, I would exist in a series of adult day programs for the rest of my life. At one point, sometime in my late elementary years, I was in a classroom simply known as Room 20, where kids the district did not know what to do with ended up. We did circle time, story time, music, walks, and maybe there were some attempts at teaching us three-letter words like cat, dog, etc. I was bored out of my mind. In 2022, Hari graduated from UCal Berkeley with a 4.0 GPA. He was awarded the Paul and Daisy Soros Fellowship and is currently working on his PhD in neuroscience at Vanderbilt University. He has authored articles for Newsweek, Psychology Today, the Boston Globe, Time, Fortune, and numerous other publications. There are so many others like them. What made the difference for these people is that somebody in their life introduced them to spelling as a means of communication and stuck with them. This has gained a great deal of momentum in recent years as there's been a book, a movie, and a lot of talk among parents and other family members of people with autism. So why do we need this bill? Because there has been some pushback, and in particular, there's been pushback from the American Speech and Hearing Association, also known as ASHA. And ASHA's objections center primarily around the statement that spellers need a facilitator or communication partner. Early on, they do. When you see somebody who's graduated to using a keyboard, you can see with your own eyes that that is not a dependency, and it certainly is not a lifelong dependency. One parent said to me, our son's been doing speech therapy once a week for 35 years. He still can't speak. But ever since he has learned to communicate with spelling in a matter of months, he can now tell us what he wants for dinner. He can tell us what he likes and dislikes about his living situation. When we take him to the doctor, he can answer specific questions about where he hurts and what kind of pain he's experiencing. This is life-changing. Nevertheless, the pushback continues. The state of Massachusetts in December issued guidance warning service providers against spelling to communicate and stating that they were deferring to ASHA's position on this. So I feel like ASHA's position is easily disprovable. You can see it with your own eyes, yet the state of Massachusetts has deferred to that position. I have also written an email that attaches that letter, and you will all get a copy of it. I also provided a copy to the clerk. If we want to help people with apraxia, we need to make sure that that innovation can move forward. Families are telling us that this is life-changing for their loved ones and for everybody around them. I also have a letter which I'm emailing to the committee that from a group of scientists, researchers, and even one speech therapist who say ASHA's position is not scientifically based. And they lay out specific details about some statements and presentations that ASHA has presented and why those are simply not scientific. And they're calling for a more rigorous scientific approach to look at this because it is making a difference for people. So This bill would amend RSA 171A, adding a new section confirming a person's right to use a preferred method of communication. This is modeled after a law that passed in New York. I felt that was a bit too broad and that it had the potential to create unintended consequences. So I pared back the New York language. And essentially this says somebody has a right to use their preferred method of communication. And that including but not limited to
10 seconds.
Okay, augmentative, alternative communication. You can see them listed here, but essentially, I see this bill as something that upholds self-determination and dignity, better access to services, and while New Hampshire's Bureau of Developmental Services already emphasizes person-centered planning and inclusion, this bill would explicitly address the preferred communication in statute.
Thank you, Representative, for all of your very good information. Would you possibly agree that the problem that exists in our educational system is that our educators are not diverse enough in any school, whether it be public or private, to actually be able to teach these young people at young ages, as opposed to waiting until somebody has an epiphany?
Thank you for the question. I think that there are people on the front lines who work very hard and dedicate their lives to helping people with disabilities. My concern is that very often they're working within a sort of narrow scope that is defined by academics and researchers who, in some cases, have a stake in the game. ASHA is a professional association that perhaps sees spelling to communicate as a threat to what they're doing. I would actually hope that they would embrace it, and I think a lot of speech therapists, including the speech therapist who started spelling to communicate, is one of the methods available. She is a speech therapist. I know of a speech therapist in New Hampshire who is also certified to teach this, and she says I kind of have to keep a low profile because but it would be bad for me as a speech therapist if I were too vocal about it. So I think there is some narrowness of thinking. Yes.
Thank you. I ask you that because in my family there is a young lady who has autism, and by the age of 9, she taught herself how to speak 8 languages. But she doesn't speak much to the rest of us because I think, quite frankly, we're not as smart as her. But thank you. That was just a comment. Thank you for listening. Questions? Did I see a hand over here? Representative Corzine and then Representative Scher.
Thank you, Madam Chair, and thank you for being here to answer this. As I was studying this bill in preparation for today, I did come across an article that was specifically about facilitated control and the trouble that comes with that. Is there anything in the bill, or would you be amenable to putting something in the bill to make this more independent and not facilitated control?
Thank you for the question. I think we would have to discuss details because there are several different methods of teaching this. One is called spelling to communicate, another is called Speller's method. And you will also hear the phrase rapid prompting method. These are distinctly different from facilitated communication, but there was some considerable controversy and discrediting of facilitated communication some years ago. Having said that, because it is a motor skills issue, there are some, you can't have somebody standing at a distance or sitting at a distance even in the early stages of doing this. It requires hours, days, weeks of practice, and that does require, it's a little bit like physical therapy. You may need someone helping you at first until you develop the motor skills to do it. So I don't think it can work without some hands-on from a facilitator or its communication partner. But clearly people can graduate from that and be communicating independently.
Thank you for that clarification.
Representative Scher.
Thank you, Madam Chair. This is a kind of a technical, maybe drafting question. I look at lines 9 through 12, which have the A, B, C, D, which are represent it in the language of using any of the following methods. What I don't see here is language that says either a paragraph E that would say, or any other method. I'm not sure what the qualifying way of putting it, or in a different place, including but not limited to. Was that an intentional choice on your part, or might that be a worthy addition?
Thank you for the question. Yes, I think it would be a worthy addition. My concern so the New York law was so broad, it basically said you have a right to use your preferred method of communication, any method whatsoever. And I don't believe that it was in the disability statute per se. And there were some provisions, there were penalties involved. And so my concern was if somebody comes along and says, you know, smoke signals are my preferred method of communication, we end up inviting unintended consequences. So yes, I actually love the suggestion. I'd be happy to work with you or anyone on the committee if you'd like to change that. This was intended to be an including but not limited to. So perhaps that would be the best language to insert just before the list.
Follow up?
Follow up?
Yeah, and I don't know, it may be including but not limited to is the right language. I think I share a portion of your concern in that you haven't suggested to us that there's any accrediting agency who, so we could say any method accredited by. That language probably wouldn't work from what I understand you've been saying, but we can talk.
Representative Georges.
Thank you, Madam Chair. Thank you for coming here. Thank you for this bill. I'm really, really appreciate. And I can cry with the title, especially for the title, say Grace Law. Because I have my first grandson having that problem, and I know if I look on Sunday, she just came up with the device, keep putting for me rice, because she just wanted me to give him rice. And I think so this is very important, and I think so it's the training, especially the training for the professional, for everybody in the school, for kids to start this early is really something very important. Thank you very much.
Thank you. Representative Raymond.
Thank you, Madam Chair. Thank you for taking my question. I also really like this bill. I like the idea Representative Scher had about making it including but not limited to, because I'm thinking about other ways of communication. I have worked with a number of children who use communication devices, and so I've seen how incredibly helpful they can be. One question I had about is on line 5. It says an individual with a developmental disability who's receiving services. I wonder if you would be open to calling it a communication disability, so that it would cover folks who do not have a developmental disability, but in fact have a traumatic brain injury or some other circumstance that is not classified as a developmental disability that has impaired their ability to communicate.
Thank you. I always say thank you for the question, but thank you very much for that question, because I have an issue with the phrase developmental disability to begin with. I use it because it's throughout our statute, it's part of our nomenclature. But I prefer to believe that my concern is that the phrase developmental disability often is heard in a way that it implies an intellectual deficiency. And the whole point of this is there is no intellectual deficiency. There is a non-typical neurology, but there's not an intellectual deficiency. So I don't care for that phrase developmental disabilities. I also think that acquired brain disorders and other conditions certainly merit consideration under this, and I would love to work with you on that as well. I would want to make sure that we're checking with DHHS to make sure that whatever we pass is achieving the intended purpose.
Yeah, follow up. I don't think we could change
Follow
it.
up.
Thank you. I don't know that we could change it higher up where it says services for the developmentally disabled, because I think that's
Right.
already part of our statute.
Mhm.
But I think we could potentially say a person with a communication disability, because this section is about communication assistance.
Exactly.
So,
Yes.
so I don't know, but I think it's worth following up with legal people. Thank you.
Good point. Thank you. Representative Gregg.
Thank you, Madam Chair, and thank you for being here and bringing us this bill. This is a super important bill. I was just wondering, so in just looking at the whole thing, I wondered who determines what, if reasonable efforts, because you have in there that reasonable efforts have to be made, like who determines that, and what is the remedy for violations on that?
Thank you for the question. So I added all reasonable efforts. So I took the New York bill, I made some changes. That was one of my changes. And the reason I made that change also is because, again, I don't want to create unintended consequences of somebody coming in and saying, well, I'm going to sue you. You now have to hire, in every public library in the state has to hire someone who knows how to work with these various methods. So I would point out that the Americans with Disabilities Act uses the phrase reasonable accommodation. And so I think that is, like much of our law, there is some openness to interpretation, but it establishes a baseline and a basis for a judge to determine that.
Great, thanks.
Seeing no further questions, thank you very much for your time.
Thank you.
I'll next call Karen Rosenberg. Good morning, Ms. Rosenberg. It's been a long time. Welcome.
I know. Good morning. Thank you for welcoming me. I am here. My name is Karen Rosenberg. I'm the policy director at the Disability Rights Center. I've been in this position for, I think this is my 5th session. Before that, I represented people with disabilities, including people with communication challenges, and a variety of forums, including forums that would address their educational needs. So I'm here in support of this bill. I do want to encourage the committee, however, to look at some potential amendments that would address some concerns that we have about the bill itself. Like I said, I think that it is extremely well-intentioned and could really help improve the lives of people with disabilities. But a few issues for you to consider if you're looking at an amendment. One would be to, when the debate about facilitated communication, spelling to learn, all of that, really what it comes down to is the person with a disability being supported and enabled to communicate their preferred wants and desires? Is it independent communication? That's what we want to support. So students with communication needs do need instruction to be able to start using varying communication systems, whether it be something high-tech or low-tech. That instruction is necessary. But ultimately, the goal is for people to choose their own preferred method of communication and to be able to communicate independently. So if you're looking at an amendment, perhaps some language like that should be considered. So it's not the parent who chooses the communication method, it's the preferred method of communication for the individual who experiences the disability in a way that enables them to independently communicate their wants and desires. Another aspect of this that you might want to consider is that individuals who receive services under 171A receive a wide variety of services. It's not just group homes and schools and public institutions. So they may also receive services in day programs that are designed specifically for them. It could be a supported employment program. It could be some other kind of activities. And so you might want to consider broadening the scope of the programs and the individuals who might be working with the person who experiences the communications issues. So if you're looking at an amendment, perhaps thinking about looking at the communication, anyone who, instead of just trained staff, it would be any individual or organization that provides services and supports the individual in the implementation of their service agreement, something like that.
Thank you. 30 seconds.
Oh, sorry. I think that's really all that I have for you. I'm happy to take any questions that you might have. But thank you so much for Representative Kofalt and for all your work on this.
Thank you. Any questions? Representative Georges.
Thank you, Madam Chair. It's not a question, I think so, just like you said, for the amendment to look for individual to choose. But I think so for the children, parents need to choose.
Well,
I think so. I don't know.
It's actually, I think that ultimately the goal is, even for a child, what we want to steer away from is communication that is completely directed by another individual, because that is not necessarily going to be what is going to enable the individual to communicate. So ultimately, we really want, we want the child to be able to independently communicate. So you're right, it gets in this kind of gray area when you're in a school and the parent is the person who is helping to write the student's individualized education program. But still, I think the goal ought to be independent, allowing that student to independently express their desires.
Follow up. Thank you. If I say this because for my grandchildren, when she was in New Jersey, the mother didn't know really about all those things, what to do. But when he came to New Hampshire, because he came here after when it was COVID, and put his child in school, if she started to understand a lot about this, and she started to follow herself, and one of my daughters to have a problem, that was the things to make them, if the parent didn't know just on the child, I don't think so she couldn't be successful. Even to have a device, the mother is supposed to stand to ask her all those things, because when she understands, they're supposed to give her, they're supposed to give the son the device. That's what
Right. Well, the parent ought to be involved. A parent is a critical member of the student's individualized education program. And a student who has this level of communication deficit that we're talking about, or it may not even be a deficit, it may be that they're not communicating in the way that we would expect them to communicate. We need parents need to be involved in developing programs for their children. And also the child needs to be assessed by someone who is a speech language pathologist with a specialty in AAC, the Assistive Augmentative Communication. And those folks are amazing, I can tell you.
Thank you. Representative Scher.
Thank you, Madam Chair, and thank you for your testimony. Would it be possible for you to send me an email that gives specific language for the amendments that you recommend?
Of course.
Thank you.
When do you need an email?
Sooner the better.
Okay, I'll work on that.
I have a question. The amendments that you discussed, you did turn in some written testimony. Are the amendments in that?
I didn't turn in written testimony. I think that was Chase Eagleson.
Oh, I'm sorry. Yes.
He's more organized than me.
So can you email the entire committee your suggestions for amendments, please?
Of course.
Thank you. I appreciate that. And please include Representative Kofalt in that.
Yes.
Thank you.
You're welcome.
Representative Scher.
I would point out when you go to the general court website for this committee, because I am a substitute, my email is not there, so just.
You're
I
right.
will make sure to add you.
You're right. So I didn't say not just Representative Scher because of that.
I understand.
And we are glad you're here. Thank you.
Okay.
Thank you so much. I see no
You're
further
welcome.
questions. Thank you for
Thank
coming.
you all.
I do not have any further pink cards and I see no further hands raised, so I will. Yes, sir?
Mrs. Chair, I am exactly one of those individuals with development disabilities, and because of that, I got lost 3 times, and I didn't come here in time. I have my written testimony.
You're welcome to pass it in.
Thank you, ma'am.
Right there. Thank you kindly, sir. And thank you for passing that down, Representative Scher. And I will close the hearing on House Bill 1215. And at this time, I will give the clerk a minute to get herself ready for the next bill.
What happened?
I don't know. Somebody popped up?
You said something that made it switch to the internet.
Maybe
Madam
it was the
Chairwoman?
bang. It was the Big Bang Theory.
Maybe. Thank you.
I don't either, but is that, who's that gentleman? I don't know who represented, I don't recognize. Yeah. No, are you talking about Senator Long? No, Representative Long. Well, I know there's 2 of them, and they're both from Manchester. Yeah. Oh, yes. Okay, let's see if I can contact him. Yeah, we did. Right.
Yes, and I was, and remember I was like, I'll make the form, and but they have to contract out a subcontract.
What is his?
I was.
Do you know what his first name is? It is.
He's Patrick.
He goes by Patrick. Okay.
I'll make the form.
Because we didn't have a form. Literally only because we didn't have a form.
I'm now going to open the hearing on House Bill 1377, and I will now recognize Representative Long to introduce his bill. You have 3 minutes, sir.
Madam Chairman, members of the committee. So this bill is designed to make it easier for parents to ensure the care of their children if anything happens to them, whether that's a medical emergency, an arrest, deportation, yeah, a mental health or substance crisis, any number of things that could make a parent unable to care for their child for some extended period of time. Most states have, so right now in New Hampshire, if any of those things were to happen, the only way a parent can ensure that someone else has authority to care for their child is through a guardianship, and they or the proposed guardian have to go to court and file for that guardianship. So that's a fairly extensive and invasive process. Most states have some outside of court alternative, whether it's caregiver authorization affidavits, as I proposed. Sometimes it's a special form of power of attorney. But the majority of states do have an alternative to going to court and seeking a guardianship because where there's agreement between the parent and the proposed caretaker, there really is no need to get courts and attorneys involved to spend that kind of time and money. So this provides that alternative to allow them to do that. And I'm open to questions if the committee has any questions.
Thank you. Representative Gregg.
Thank you, Madam Chair, and thank you for being here. So I utilized this when I lived in Colorado and was a single mom. Is this a pretty standard form that you've put on here for different places?
Yes, I think so. So I'm familiar with it because I practice, so I'm a lawyer and I practice in New Hampshire and Massachusetts. So I use the Massachusetts model that I'm familiar with, but my understanding is it's pretty similar in other states as well.
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. We had a similar bill in the past, and the issue was the form, I think. So I'm excited to see this with the form. But my question is, on the last page of the bill, you have a section for a notary. And I know from my time at DCYF that currently parents don't really have to get a notary. If they are, for example, going to be in the hospital or have some other temporary plan, maybe the kids are going to grandma's for 2 weeks, they literally just write a letter, they both sign it. It's not typically notarized. Would this change that process so that if the kids are going to grandma's for 2 weeks and they want grandma to be able to take them to the doctor or whatever, or take them to Bible camp or whatever, that they would have to have it notarized? I worry about barriers.
That's not the intent of it. I would have to look at the language to see, but I mean, that is something that certainly is not the intent of the bill. And if the committee is concerned about that, I'd have no objection to an amendment to prevent that from being necessary.
Representative Levesque.
Thank you, Madam Chair, and thank you for taking my question. So would this be for like if the parents are going away for like a weekend and have like a babysitter, an emergency comes up, and the babysitter has to take them to the hospital or urgent care or whatever, this would allow them to bring them to urgent care and get them treated?
That is one potential use of it. I mean, I think really, medical and educational decision making, the kinds of things that a temporary caregiver normally is not in a position to do, are the things that it's meant to cover.
Representative Corzine.
Thank you, Madam Chair, and thank you for being here to answer questions. I had two concerns, and that is there any vetting involved of the, and I only bring this up because it's more than just like 2 weeks at grandma's. In the bill, it says 2 years. Is there any vetting involved for the people that the children are going to? And my other question is, could this be used to circumvent a DCYF investigation as far as the parents giving the kids to someone else before they're actually involved in care?
As far as the first question, I think the vetting would be up to the parents because no one is forcing the parents to do this. So it would be someone that they trust to take on this role. And I think, ultimately, if the parents have not been found to be unfit, we, as a state, trust their judgment to make those kinds of decisions. As far as circumventing a DCYF investigation, I think that would depend on DCYF's policies. I don't see why it would in particular. I think that if that might be a satisfactory resolution of a situation, where maybe a parent who has, for example, a drug problem could put the kids with someone else, agree to go into treatment, and then DCYF custody becomes unnecessary because there's another appropriate caregiver for the child. But I don't see any reason that would necessarily prevent DCYF from moving forward with an investigation. And if DCYF had concerns about the chosen caregiver, then that's obviously a factor in the investigation and in their decision to seek custody of the child.
Thank you, Representative Scher.
Thank you for your testimony. Thank you, Madam Chair. My question is, I give my child to my sister to take care of while my wife and I go on a one-week vacation. Child has a medical emergency, and my sister takes the child to the hospital. Will the hospital recognize this form as allowing that person to make medical decisions? Have you talked to healthcare providers whether this is an adequate form, or is it alternatively, is it your understanding if this statute passes, they have to recognize the affidavit?
I think if the statute passes, they would be required to recognize it, and that is what my understanding what other states do.
Thank you.
Seeing no further questions, thank you for your time. And thank you for introducing the bill.
Thank you.
The next pink card I have is Richard Menard. Oops.
Thank you. The red light scared me. I'm
And you'll have 3 minutes.
Thank you. I'm Richard Bernard. Until very recently, I was the executive director of Building Community in New Hampshire, a nonprofit organization based in Manchester. We work statewide with people who have come to New Hampshire as refugees or with other government permission to be here. And in that capacity, we have come to work with many families who fear being detained or deported. They're here legally, but things are changing for them, and it's difficult for them to be sure that they'll get home at night and be there to take care of their kids. Because of that, we embarked on a project to help those families adopt caregiver plans, formal documents that would be legally binding. And we sought an attorney to help us with that process. Because an attorney was required, we eventually hired Patrick Long, who just spoke, and we were able to help families create caregiver plans. It's a difficult process for those families emotionally, especially emotionally, but also tactically. It requires an attorney who's willing to spend time with them. This bill would help that process enormously by making it simpler. Parents who fear being detained or deported could merely go find an appropriate person to sign with them, but then to have that form notarized. It would give them great peace of mind, and if in fact the parents were detained or deported, someone they trusted would be there to take care of their children. This is not an immigration bill, but many families, particularly those from Afghanistan, Ukraine, and Haiti, and there are hundreds of those families in New Hampshire right now, would have a great deal more peace of mind. And if worse came to worse, their children would be better taken care of. I'd be happy to answer any questions.
Thank you for your testimony. Do I see any questions? I see none. Thank you very much for your
Thank you.
time.
Let me just add, I presented a letter written, co-signed by Nicole Schultz, who's now the executive director of the organization. She couldn't actually sign this form, but we will get you a copy with her signature on it as well. Thank you.
you. Representative Long, did you want to submit any written testimony? Okay, thank you. The next card that I have is from Yama Pluskonka. You may have a seat. You'll have 3 minutes, sir.
Press the button. Oh, thank you. This is my first time ever presenting testimony for a law. I was a legal aid when I was a kid, but boy, I'm glad. I'm grateful. I'm sorry that when I marked, you're supposed to mark yes or no. Are you on support? I marked no, and I would want to say why I don't think that this is a good bill. As Senator Long a minute ago explained to intentionality, I think that that's fantastic. I am all for making things simpler for people. That's why we moved to New Hampshire in part. It's because things are like we rely on each other in a more simpler basis. However, what worries me, and with all respect, I may be completely wrong, I'm just a voter out there, I'm concerned about how broad this bill is and in changing something that I think shouldn't be changed. This morning, and one of the reasons why I was late, and I'm not using this as an excuse, we have California visitors or cousins, and I was explaining to my 10-year-old niece or cousin how we make things in the United States because she doesn't know that. The separation of powers, and how important is that these powers be balanced and check on each other. With this bill, a parent can write a piece of paper and bypass the judge. Now, how much the judge will actually check under the hood for a guardianship arrangement and really, is this a good idea, not a good idea? I don't know. But at least we have there one step of check and balances. With this bill, that goes away. What I am worried is about unintended consequences. This is a fantastic concept, but maybe I'm paranoid. Think about what would, we had that story about that country singer who could mark adopted his underage friend and that way bypassed things. In this case, what about human trafficking? I get a parent to sign a piece of paper. I have hold of this child without any supervision. I mean, I'm extreme, but you know that laws get misused, and that's the way of the animal. And I admire you for your work in trying to keep things straight and good. The intention is good. Let's make things simpler. Let's make things affordable. Let's not put the burden of going to a lawyer and all that. Yes, totally for that. What else can I say? I appreciate this.
Thank you. Are you aware that in the cases that you're talking about, that obviously can happen? However, for the court cases, people can go to the court and ask for another person to temporarily be the guardian of a child, and the court will, if it's in the best interest of the child and the family, do that, and there would be a court order issued.
Thank you, ma'am. I am not aware of the particulars of that, but I believe that that makes entire sense, especially the magic words, best interest of the child. I believe in best. I was a CASA worker for a while, and I believe in best interest of the child. Yes, ma'am. And we, my wife and I, and well, this is none of your business, but whatever, we are appointed guardians for our nieces and nephews in case our in-laws would have an accident or whatever. So, yeah, it can happen.
Thank you very much for your time and effort and your testimony.
Thank you.
Do I see any questions? Representative Corzine.
Thank you, Madam Chair. Thank you. I believe we share a lot of the same concerns, because those were my concerns too. Is it's a lot different for your children to go visit your in-laws for a month than it is to give somebody else custody for 2 years. The 2 years part does scare me. What would you like to see different about the bill?
I'm good at finding problems. I'm not as good at finding solutions. I mean, if we had some means of keeping some level of check and balances, I am very afraid about the capability of this EYF of doing anything constructive. I'm sorry, but and I have been a foster parent over 2 years, and that's a long story. Let's not go there. But yeah, what I would want is some kind of like this is not a blank check. What I see here is a blank check. That's what I see here, and
thank you, Representative Gregg.
I know that we, thank you, Madam Chair, and thank you for being here and taking my question, and thank you for making all of the effort to be here. Are you aware that sometimes there are even service members who will use something like this? The deployment is about 2 years, so that's why something like this is necessary to secure their children, because in this state, we have determined that really the parents usually know what's best.
let us have a properly drawn guardianship document that gets overseen by a judge. I'm afraid that the judge, what will the judge say? But at least it's a matter of, I don't know, maybe it's not public record, but at least it's a matter of record that this exists. This is a private document. This is me saying something that has force of law the day that somebody is taking my kid to the hospital or whatever. I mean, and taking a kid to the hospital, that's covered by Good Samaritan law anyway. I'm not going over there. The point is, with all respect for service members, I do believe that they have free attorney services offered to them to draw their wills, to why not this?
Thank you. Any further questions? Seeing none, thank you very much for your time.
Thank you all.
Seeing no further pink cards, it is 5 minutes, or actually, it is 11:52. I will not close this hearing yet. If anybody chooses to discuss this bill in amongst yourselves, by all means do. And as soon as it hits noon, we will break for lunch until 1.
Can we ask Kristen to
Ask how many people would like to do that.
Hi,
Excuse
hello,
me.
committee.
There's a question.
I was thinking maybe it would be a good idea to ask Madam Chairwoman to ask our researcher like what the other states who have stuff like this in place do and what their wording is. Is that okay? Yeah.
I will do that. I will send her an email asking her to do that. And with that, I will close the hearing on 1377. Have a nice lunch. Good afternoon, ladies and gentlemen. Thanks for coming, gentlemen. Thanks for coming today. We're going to open the hearing on House Bill 1404. And let's see who the is Representative Barton in the room? I do not see Representative Barton. I'm going to recess the hearing on House Bill 1404 until Representative Barton can get here. And I'm going to open the hearing. Oh, we're going to have some time. And I'll see if I can contact Representative Barton to get here. Oh. Hello there. Yes, please. Thank you very much. Okay.
So let's just, did I need a ride home? Because we're not going to Manchester now. So then tomorrow, I going to go for the food of the hour.
So maybe he can go for his allergy shot now that he's...
said I'm going to try to make it home in time for you to do your allergy shot.
Cool.
If I can leave here by 3:30.
Oh, sure. We should be done.
I think we should.
Oops. Okay, I just spoke with Representative Barton, and he is en route. He has asked if Representative Moffett could introduce his bill, and we can talk about it a little bit. He said he'd be about 20 minutes, and we do have the time before the next bill is being heard, so hopefully he'll be here on time. Because I will close the hearing on this at 1:30. Thank you, Representative Moffett.
Thank you, Madam Chair. It's great to be here in Children and Family Law. And as you just heard from the prime sponsor, Representative Barton, he is southbound from Littleton and expects to be here in 15 to 20 minutes. And he understands the time constraints and that there is another measure you're going to take up at 1:30. So HB 1404 establishes a study committee to study the equitable division of property in divorce proceedings. And subject to any questions, I will defer to the prime sponsor. Happy to take questions. I don't know if I would be as adept as the prime sponsor to address them, but
Seeing none, I will relieve you of the agony.
it's not agony, Madam Chair. Happy to be here. Thank you, ma'am.
I know you're always happy to be here, and we're happy to have you. Thank you. So, yes. And at that, we will recess again and give the prime sponsor an opportunity to get here. We can't open our next hearing until 1:30 anyway. So, thank you. So Representative Barton is here, so we are going to come out of recess, and I will call Representative Barton to introduce his bill and speak on it. You'll have 3 minutes, sir.
Was it already introduced? Okay, great. So my thoughts with this bill and the reason why it's a study is I was looking at how Maine operates, specifically with divorces and how they have a structured division of assets that protects premarital assets. My philosophy was looking at this prenuptials, especially when you're younger, people are either not even thinking about that because everybody who gets married expects it to work and last forever. Sadly, it's over 50% now where they fail. So this study, or the focus on having a study like this, is to structure our statutes and our codes similar to how Maine has theirs structured, where it would prevent an individual from being kind of guilt tripped into not having a prenup, and then 7-10 years later they get hit, and all of their assets that they had before they got married are now considered marital assets in our state. That's how things are viewed. There aren't any specific protections. If you had like a Lamborghini going into your marriage and you keep it because you never drive it, well, now it becomes a marital asset. Whereas in Maine, it's codified, that would be separated to the party that owns it. So because of the complexities, I couldn't work with OLS fast enough to look at everything. I think it really needs a deep study to look at this, and I think it would benefit the state to have something codified and structured with respect to asset division. It would make things simpler for the judge to divide assets, and it would protect the parties without any guilt trips in the beginning of the marriage. So that's why I pushed it for a study. And let me think if I have anything else to say on this. I guess I'll take questions.
Thank you. Any questions for the representative? Seeing none, thank you very much. Thank you for coming.
Thank you.
I hope you have other business.
I do, and it's with you
Okay.
guys.
Have to get it out there.
Okay. I need to do another green sheet. Do you still have the green sheet?
I have a green sheet. I have green
When
sheet.
I have one.
Oh.
Yeah, might as well.
Oh.
She has
What?
one.
Oh, you want that one back?
Yeah.
Oh, sorry, I didn't mean to be throwing
Okay.
this at you.
In the interim, Representative Nelson, do I hear a motion on House Bill 1404?
Yes, thank you, Madam Chairwoman. I would like to make the motion of interim study, please.
And do I hear a second?
Yes, I'll second that.
Seconded by Representative Petrino. Would either of you like to speak to your motion?
Thank you, Madam Chairwoman. I actually received a letter from not even a constituent, but a person from our state regarding this very issue. And I personally would just like some more time to be able to dig in a little bit and compare the current law that we have here in New Hampshire to, Maine, the state that Representative Barton was referencing, and maybe some other states too, to make sure that we are being fair.
Do I see any hands for further discussion? Seeing none, I'll ask the clerk to call the roll.
Thank you, Madam Chair. Representative Pearson,
Yes.
Representative Nelson,
Yes.
Representative Love.
Yes.
Representative Corson, yes. Representative Moffett,
Yes.
Representative Petrino,
Yes.
Representative Scheer,
Yes.
Representative Levesque,
Yes.
Representative Gray,
Yes.
Representative Raymond, Representative Georges,
Yes.
and Chairman DeSimone,
Yes.
12-0.
I hear a motion to put this on consent. Do I hear any objections? Seeing none, the Representative Love seconds that. On consent it goes.
Good luck. Thank you. 12 zip.
Thank you, yes.
Thank you. Yeah, I
Oh,
think
please,
that's
there's two last week.
consent. Yes, I just think that's just fair. Consent. Spokesman Johnny Nelson. Okay, thank you. You know what I almost did again, Lori? I almost filled out this on the wrong bill. Remember last time I was like, why am I doing this?
Yeah.
So that was why I was very discombobulated.
Representative Scheer, did you have to be reminded?
Yeah, exactly. Moffett is the one who saw fit to join it.
Thank God we have Representative Moffett in the house.
Reminded Representative George, reminded Representative Scheer, so it's a team effort.
I love it.
I love it. I love it.
You did. Okay, so I just want to let the committee know that one committee member had to leave. She will be back, but I have promised her we would not accept the next visit.
Okay, yeah, that's fair. Okay, now I have to write the number. I am going to be reeling.
Okay, we're not, but she should speak today when we hear the bill. Okay, the next bill. You're going to open the next bill, Jody?
Oh, yes, I'm very
Don't
sorry.
rush.
Just one moment, please. I have to find the blurb. And sorry, I completely forgot. That's what I was doing next. And here it is. I have to fill out a pink card too. Yeah, she's really sick.
I'm closing the hearing on House Bill 1404. And I'm going to open the hearing on House Bill 1643. And I'll invite Representative Nelson to introduce the bill.
Thank you, Madam Chairwoman, and thank you to members of the committee. I am introducing this bill for the prime sponsor, who unfortunately is very ill today and will not be able to make it. I also have her testimony here, which I will read for you right now. For the record, my name is Joey Nelson, representing Rockingham 13, Derry. It's regarding House Bill 1643 relative to the report of a guardian ad litem. HB 1643 reinforces the proper role of a guardian ad litem as an investigative arm of the bench, not a substitute decision maker. Guardians ad litem provide valuable fact gathering by interviewing parties, reviewing records, and presenting the court with a detailed report about the child's circumstances. That investigative function remains fully intact under this bill. What HB 1643 does is ensure that the ultimate responsibility for allocating decision-making authority, crafting parenting plans, and setting schedules rests where it constitutionally belongs, with the judge. Judges are fully capable of reviewing the GAL's findings and reaching their own conclusions without a proposed outcome attached. This protects judicial independence, reduces the risk that personality conflicts or subjective impressions are given undue weight, and preserves due process for both parents. Importantly, nothing in this bill prevents attorneys from asking a GAL during testimony what they would recommend. It simply prevents the court from requesting that recommendation in the written report. This keeps the final determination squarely in the hands of the court while maintaining transparency and fairness in the process.
Thank you. Any questions? Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. My question is, under the statute now, the GAL has to represent in their report what the child's expressed wishes are, and if they have a different feeling about them. So if the child says, I very much want to go home, the guardian ad litem would say, the child has reported to me that they very much want to go home, but they also can say, however, I don't recommend that because, mom's in rehab or whatever. Would this change that part of their obligation?
I don't know the answer to that question.
Representative Petrino.
Thank you, Madam Chairwoman, and thank you, Representative. Hopefully you can answer my question. I'm just wondering if this, in your opinion, would increase the burden on the courts. Now, judges would have to spend time developing parenting plans themselves, and the courts are already overburdened with so much work. Do you see this as a potential problem?
Thank you for the question. I do not see this as a potential problem. The problem that I have seen and people have talked to me about is that the judge is solely relying on the recommendation of the GAL in order to give their decision. Instead of using it as a tool, they are relying solely on the recommendations of the GAL. And of course, the fact gathering and so forth from the GAL is very important, but that should be only one part of the equation when they're determining their decisions.
Any other questions? Seeing none, thank you, Representative.
Thank you.
The next card I have is from Denise Costello. Good afternoon. You can turn your microphone on.
Thank you very
And
much.
I'll give you 3 minutes after you introduce yourself. Thank you. Turn it on again.
My name is Denise Costello. I am a resident of Concord, New Hampshire. I didn't come here expecting to say anything today, but after looking at the statute and the checklist of what a guardian ad litem is sometimes tasked to do, it made me want to just add that I agree with what Representative Nelson was saying. I think that the role of the GAL is clearly investigative and should be. In the request to take out an allegation ABC on here, I believe there are other things on the checklist. If you're going to remove this, I would request that you look at a few others. I believe that you have to question the qualifications and the expertise of the GAL and what he brings to the table in terms of, say, ongoing training and things on issues like the bond of children with their parent. I don't see anywhere in the GAL perusal that I've done with their qualifications and their training where there's a lot of training or background where somebody should be making that decision other than a judge, based, of course, on the GAL investigative report. I don't think they should be making that recommendation. I think it should fall on the judge.
Would you take questions?
Yes.
Representative Petrino.
Thank you, Madam Chairwoman. Thank you for taking my question. And I apologize if I wasn't paying close attention to your testimony, but I just want to make sure. Did you say that current statute already prohibits the GALs from making these kinds of recommendations to the courts? And
No.
again, that's my fault if I did not hear you
No.
correctly.
On the contrary, they do. In the GAL questionnaire, the judge has a checklist where he will say to investigate allegation of decision-making responsibility, and there are probably, I'm guessing, maybe 15 or more check points. One of them is to assess the bond of the child with the parents. And there are a couple others that I would question that a GAL is qualified, trained to do some of those that are on the checklist. I have the checklist with me if you want me to. So, is this on? So just to name a few that come into question is assessing the bond between child and each parent and or siblings. There are just some that come into question, like appropriateness of the home environment. I think that as humans, we all bring bias to the table. Maybe it involves more than just the condition of the home, which you would want it to be neat and tidy. But, you know, it just seems like it's substance abuse. How can he determine that without some special training or at least some records that something has happened? Residential responsibilities, decision-making responsibilities, parenting time. I mean, it's already established that the best interest of the child is 50-50. You can have your own parenting plan, which has a different division of time in each home, but the parenting time should be worked out in a parenting schedule, not something that GAL writes up based on an investigation, dynamics of schedule changes and that kind of thing. I didn't come prepared. I apologize. I hope that answers your question.
You're doing well. Thank you. You're giving us good information. I appreciate it. Are there any other on the checklist that you are concerned with?
My point in testifying was to say, if you're looking at those three listed in the proposal and the statute, you should look at all of them and bring your expertise to the table, and or whoever sponsored the bill, those who sponsored it and support it, to make decisions as to whether they wanted to add context to that, like the bond of a parent and a child.
Thank you. Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. I was just trying to Google quickly on my phone, which is not the most efficient way to do it, the checklist that you're referring to, and I couldn't find it in like the 3 seconds while you were talking. I'm wondering if that's something that you have a link that you could email the committee?
It's you could probably find it on the, wait a minute.
Because I want to see it now. I'm curious about what all the items are.
What I have in front of me is part of a court order on appointment of guardian ad litem. So it would probably be on the court website, if it's a standard form that judges use to appoint a guardian ad litem.
Well, I'm gonna write
And if not, I'd be happy to do some redaction.
Yeah, I don't want anything that has personal information on it, obviously. But order on appointment of guardian ad litem, and we think it's a judicial form.
Yes.
Okay. Thank you.
In the family division, of course.
Thank you very much. You gave us great information and we appreciate it. Oh, I'm sorry. Representative Corzine.
Sorry, Chairman.
No,
Thank you for
don't be.
taking my question. Thank you for taking my question and being here. So just to clarify, are you saying that the guardian ad litem needs to report more on objective evidence rather than their gut feelings and whatnot? My experience as a foster parent here in New Hampshire with both DCYF and the guardian ad litem was just awful. She told my kids that because of my political leanings, I was probably racist. So, and that made it into the report. So I just wanted that clarification that they should be able to report objective findings without bringing in their gut feelings.
100%. I think that the GAL board should have, everybody has biases, it's just natural, but they have to approach their job when it comes to the best interest of the children. Children's futures are dependent on them not being biased in those regards, as was your experience and many other women. And unfortunately, the women who are, or the families that are involved with the guardian ad litem are already involved in family court. What is most disturbing to me is that these parents are spending tens of thousands of dollars in family court already, and now they have to pay a GAL, and I don't think they're getting an unbiased or qualified opinions at times, not criticizing the whole process or GALs in general. But I think that a perusal of the GAL website makes me wonder who's paying attention there. I know of a complaint that was filed, and it's my understanding that one of two things can happen with a complaint to the GAL board. they either one dismiss it or they make a decision to investigate it. Somebody I know filed a complaint. Next week will mark the 2-year anniversary and has never heard a thing despite following up and asking what's going on, only to hear that they have a lot. I looked at the graph from 24 to 25 and the number of complaints have increased. So if they're already taking more than 2 years, what are they doing now that it increased in 2025 or 23 or 24, 24, 25? Might have been 23, 24, 25, might not be out. I apologize for not being clear on that. Thank you.
Representative Scher.
Thank you, Madam Chair, and thank you for providing us with the information. On the court website right now, what is it? Do you have the title of the form that you're talking about?
Yes, it's from the state of New Hampshire Judicial Branch. It's entitled Order on Appointment of Guardian Ad Litem. Underneath, it's parentheses, divorce/parenting.
Thank you.
Representative Petrino.
Thank you, Madam Chairwoman. Thank you for being here to answer our questions. I appreciate it. So when the guardian ad litem is doing their investigation, and when all is said and done, an opinion has got to be made. Someone has to make the opinion. Do you see that a judge would have any more insight than the guardian ad litem in terms of assessing and formulating an opinion based on the evidence that has been gathered? In other words, someone's making a decision. Right now, the guardian ad litem is making a recommendation. We turn it now instead over to a judge. Does this judge have any more insight than the guardian ad litem to justify their opinion on the case based on the evidence that was gathered?
Sometimes. Sometimes. I think it depends on the judge. When you have a case that's been languishing in family court for 2.5 years, and a judge presents at a status hearing, he's not looking at the record and following what has happened. He's looking at today's hearing and a little bit of history of what's involved in the motion for whatever, let's say contempt. He's not looking at the whole thing. Some judges are more diligent and seem to bring more to the table in understanding some of the dynamics of, things that are involved in divorce proceedings, contentious divorce proceedings, like domestic violence, interference with custody, finances, so many things. So it depends on the judge. I can't speak one way or the other. It depends on the judge. Some are better than others. And
So may I have a follow-up, Madam Chairwoman?
Follow-up?
Thank you. So if that's the case, and I do agree with you on that, then what then would be the rationale to take it out of the hands of the guardian ad litem to make a recommendation? Because they're the ones who are closest to the case. They've seen it. It's still fresh. The evidence is right there. And they assess and they make a recommendation to the judge. And now I'm hearing you saying that some judges, it may languish. They're not familiar with the case. So I'm just trying to understand what then would be the rationale to change what currently is in practice and just turn it over to judges?
well, I think in all instances, I guess a new set of eyes, a new pair of eyes can be relevant to a court hearing. The court does not have a lot of time for family court matters. You have half-hour hearings, status hearings, and you're waiting 2.5 months for the next hearing. Nothing is, it's ongoing. So this is just another piece that's ongoing that is disturbing because, like the judges, I don't think you're always going to get a GAL who has his finger on the pulse of what is happening. So again, it'll depend on the GAL. It's another pair of eyes. He may get it right and he or she may not, but it is another pair of eyes, and the court seems to think it's relevant. I mean, the GALs have been around for a while, but there are some criticisms about the process, and like I said, their inability to remove bias, and there's no training. Doesn't seem to be an awful lot of training. There should be more training. I've read in their minutes where Board members have said they'd like to see more training, but then I don't see more training, you know. And that's just a peripheral view, so I can't say I came prepared to speak to it. Yeah. Thank you.
Thank you for that. Any further questions? Thank you very much for coming
Thank you
before
for
us
the
today.
opportunity. I appreciate it.
We have about 10 minutes before we can close the hearing. I'm going to wait to see. Oh, yes, I'm sorry. I have one more card, and it's for Mary Kruger. Come on. I handed in your card quicker than I should have.
Thank you very much, Madam Chair and members of the committee. My name is Mary Kruger. I'm with New Hampshire Legal Assistance. We're a statewide nonprofit law firm providing civil legal services to low-income clients to meet their basic needs. And I supervise our domestic violence advocacy project. And I just thought I would give some information to the committee about this. I didn't take a formal position. We at New Hampshire Legal Assistance had decided to keep our eye on what happens with this bill. I can say that it probably doesn't go far enough, and I agree with Representative Rice's through Representative Nelson's reading testimony about some of the issues that we've had, and this committee has worked on this, I know, in the past, and we did make some changes to the GAL law where the court would have discretion over whether or not to direct a GAL to look at the allocation of decision making, create a parenting plan or a specific schedule, and that is discretionary currently, and that was a decision made because of the concern that courts were relying too heavily on the recommendations of a GAL when the GAL really ought to be gathering the information for the court to be able to assess the best interests of the child, and that it really is the judge's job to be the one to make that determination. Now, I do want to just clear up a couple of things. We have really two systems of guardians ad litem. Representative Corzine was talking about the GAL system within the context of DCYF. That is through CASA, which is a nonprofit where they have guardians ad litem who work specifically on abuse and neglect and termination cases. In the family division and under RSA 461A, which is what this bill addresses, we have guardians ad litem that are private individuals who go through a licensing with the state that has certain requirements, and then they have that license, and then they are listed with various courts as being available for parental rights and responsibilities cases. There is much less oversight of that program than there would be in the CASA program. And really, they're independent actors, these GALs. So there's a wide variety of experience that they have. They may or may not be attorneys. They may or may not be social workers. They may or may not have the qualifications to determine what developmentally a child or children need. And then there's the expense when these cases do go on for years and years. Even though we put some things in place to cap 23 hours as the amount of time a GAL ought to be able to complete their work, often those are exceeded by filing motions with the court. So it's a system that is broken. There's no longer public funds available for low-income families to be able to access, and we have a discrepancy there where people with means can have GALs, and those children may or may not benefit from that, whereas low-income people do not necessarily have that same access. So we do have a lot of issues. This is a problem I think we've talked about multiple times, And I just wanted to express that sort of broader landscape for this committee to hear about. Thank you.
Thank you. Representative Scher, will you take questions?
Oh, absolutely.
Thank you.
Thank you, Madam Chair, and thank you for your testimony. Do you have, could you describe, if you know, the nature of the licensing process for GALs? How significant is that, or how insignificant is it?
Yeah, I mean, I'd have to go read it, and it's been a minute since I've had the chance to do that, and I did just figure I'd come up here and talk about what's in my head and not necessarily on paper.
Statute?
Yeah, it's all in the license. It's part of the licensing board. So if you look up whatever the office is, yeah, it's there. And then there's all kinds of rules and everything. And there is a process for complaints as well. And we heard a little bit about that. Complaints can't actually be filed until a case is complete, which makes sense. However, it also means that sort of the damage is done before you can really have an official complaint if someone's not doing their job. And we do see people really not doing their job. Some are very good at this and some are not so much.
Any further questions? Seeing none, thank you very much.
Thank you.
I appreciate your time.
You're welcome.
We have about 2 or 3 minutes to relax a little bit before I close the hearing. If anybody has any further questions, they're welcome.
On condition, not infliction.
Being that it's 2:01, I would now like to open the hearing on House Bill 1687. And I ask Representative Love to come up and introduce his bill, and I'll give you 3 minutes.
Thank you, Madam Chair. Thank you, members of the committee. For the record, my name is Representative David Love. I represent Derry. I'm introducing this bill because I see it as a problem. It's been a problem for a long time in the courts, where someone will come in, whether it be a husband, wife, or a co-inhabitant, saying that there's been, say, an assault. The woman's been assaulted by a man, or a man's been assaulted by the woman, and it kind of gets buried in family court. They'll take it and write it down, but there's never any charges. And I'm sorry, assault is a crime, and it belongs in criminal court. Especially when we're talking about assaulting children. That happens, and it kind of gets swept under the rug. And we've got to stop that. If there's accusations of crimes going on, whether it be drug dealing, whether it be assaulting a child, whatever, put it in a criminal court where it belongs. Have criminal investigators investigate it, and and have a reasonable outcome, a truthful outcome come out of it. All too often, like I said, things get swept under the rug in family court. They try to make determinations without ruffling too many feathers or something. I don't know why they do that. But the fact of the matter is, crime should be adjudicated in the criminal court. Any questions?
Thank you. Any questions, Representative Scher?
Thank you, Madam Chair, and thank you for your testimony, Representative Love. My understanding of the way the system works is if someone goes to the police and says, I've been assaulted, then the police do the investigation. The police are the ones, or the prosecutor, one or the other, sometimes the police are the prosecutors, they're the ones who bring the criminal charge. Is it your understanding that judges in family court can bring criminal charges?
No, they should. Thanks for the question. They should refer to the police. If this is accusations, and the judge feels like this is really going on, maybe a restraining order where somebody shows up with black eyes and fat lips, and they don't have enough sense to go to the police, they should refer it.
Follow
up.
My guess is there's some confusion because in family court, because if one partner in a marriage comes to the court and says, my spouse hit me, is it your understanding the family court has the power to order, for example, a restraining order, right?
Yeah.
And that's separate from the spouse who was hit, the victim, going to the police and saying, I was hit, I'd like you to bring a charge.
Like I said, I think a lot of times there's a big fear factor. Thanks for the question. There's a big fear factor. A a spouse that's been beaten will, you know, kind of just take the restraining order and hope for the best where there's been a crime committed. You know, let's prosecute the crime. If we prosecuted these crimes, there might be less of them.
Thank you.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. I have so many questions about this bill. If I have your indulgence to ask more than one, I'll start with a technical question about a line. On line 9, at the end of the line, it says criminal penalties, et cetera, shall be reserved for the Superior Court. I'm curious about why the Superior Court, because my understanding that there are a lot of misdemeanor level criminal charges that happen at the district or circuit level, whereas Superior is reserved for felonies. So my question is, am I wrong about that?
My answer would be, let's amend that because I didn't catch that. Criminal court, it should be.
Okay. And then follow up. Thank you for indulging me. And then I guess my follow up is piggybacking off of Representative Scher's questions. I've worked with the police a lot over my career, and one quote that I've heard a billion times when doing a dual investigation with them, like for example on sexual abuse or physical abuse of a minor, is that if there's no victim, there's no crime. And typically a police officer will say that to me when the victim themselves does not want to go through the process of a trial. We see this a lot with children, and when they don't particularly want to put a child on the stand to testify against a parent. Would this take away the agency of a victim to determine for themselves whether they want to participate in a criminal proceeding?
Thanks for the question. Quite often, you know, in an adult, I suppose it would. Maybe we need some language there to, but when it comes to children, they can't make that decision. If it happens, it happens, and we should be protecting them. You know, yeah, there will be parents that pressure them to lie. You know, I've seen that many times, and you know, that a professional investigator should get by that, get around that, and find the truth. But you know, allowing it to be swept under the rug shouldn't happen.
All set? Representative Petrino.
Thank you, Madam Chairwoman. Thank you, Representative, for taking my question. And I wanted to know if you were aware of legislation 2 years ago, House Bill 1192. It was a Republican-sponsored bill, and it did pass this committee, and it went to the House, and it passed in the House as well. It stalled in the Senate. And that particular legislation would have allowed the family division to incarcerate parents who willfully violated parenting rights. And some of the sponsors of that bill are still sitting on this committee. And like I said, it went through the process. Would this legislation before us now negate the possibility of that previous legislation from going forward?
Well, thanks for the question, by the way. You mentioned parenting plans. This is different. This is a you know, a violent criminal act is what I'm trying to stop here. You know, to have you know, criminal acts be brought before a criminal court, and
May I just have a follow-up on that?
Follow up?
Thank you, Madam Chairwoman and Representative. But my point being is that the family division would actually incarcerate an individual, and that is criminal proceedings. And so right now it is within the jurisdiction of the family division to do just that, be it in violation of a parenting plan or assaulting a spouse or a child. And that's pretty much where I'm going with that. So, you know, we're trying to carve out a difference here, but bottom line, you put somebody in jail and the family division's making that call.
thanks for the question. I wouldn't be in favor of the family division I don't think they're equipped. Um, you know, if you're going to put somebody in jail, you better have a real good investigation done, a professional investigation by professional investigators, and you know, and have if you're going to be put in jail, you've got to go through due process, and family court doesn't do that, and you know, I wouldn't be in favor of that bill because of that.
Representative Raymond.
Thank you, Madam Chairman. I just thought of another question, if you don't mind. And it's another technical question on the language, which I had highlighted and not asked you about a minute ago, so I'm sorry about that. It says on lines 5 and 6, the judicial branch, a family branch, shall not have jurisdiction to make any criminal determinations, criminal judgments, or impose criminal penalties, and then it goes on. My question is, what about circumstances where currently family judges can hold a party in contempt of court? Like, for example, if they have repeatedly failed to attend court hearings or respond to subpoenas, if they have repeatedly failed to pay their child support. I don't actually know all of the breadth of times they could do contempt of court. Is that criminal? Would that stop them from doing that? Maybe
No,
there's an attorney.
I'm not a lawyer, and maybe Representative Scher can expound upon that. But I think if you're going to bring criminal charges, it should have to go before a criminal court.
I'm going to go off script for a second or two to ask Representative Scher if he could answer that question.
I can, in the absence of Representative Markle.
Yeah.
I accept my status as the default lawyer on the committee. There are two types of contempt. There's civil contempt and there's criminal contempt. Criminal contempt, you can be jailed for criminal contempt. You can also be jailed for civil contempt until you perform the task that you haven't performed. So being in jail is dependent on not having, like, paid a certain amount of money or doing something, executed some deed or something. But criminal contempt is you can go to jail for violating a court order. There are a mix of, for example, if there's a protective order and you violate the protective order, that's an act of criminal contempt and you can be jailed for that. Overarching point that's important to make is every judge who sits in family court is a circuit court judge, and every circuit court judge has authority over, in the first instance, all misdemeanors, and all misdemeanors are brought in circuit court. So they're really, and Superior Court handles felony criminal cases. So there really is no such thing as quote unquote criminal court, because judges have, circuit court judges in particular, can handle family matters and they can handle misdemeanor criminal matters.
One more question for you, Representative Scher, if Representative Love is amenable to me asking him a question. Is it true that the family court can refer any part of the testimony that they hear to the district or county attorney's office for further investigation?
Yeah. Really, the only people who can bring criminal charges are a police prosecutor or a city prosecutor or an assistant county attorney or county attorney. So a judge can say, can send a note, a message to the relevant prosecutor as to conduct that has occurred. But that's separate from what the family court judge might do in terms of whether that same conduct might violate a protective order or something. So there's two things going on. And the judge only has, the family court judge only has control over conduct that violates some protective order that judge may have, or he has, just because he refers a case to a prosecutor Prosecutor doesn't have to do anything with it.
Thank you. Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. I just want to know if I'm trying to, I understand your passion about this. We've talked about it, and I'm just trying to, in my own head, figure out exactly what you're saying. And I think what I'm hearing from you, and my question will come, in a second. But so, for example, if a woman is being beaten by her husband and the neighbor calls the police come and see evidence that the woman is injured, it's out of her hands. The police, out of her hands. She doesn't need to press charges. The police will arrest that person. But if that same woman appears in court, visibly injured and wants an order of protection, then that same criminal, I don't know if this is the right term, but like exercise would not happen. Is that what you're trying to remedy here?
Yes, when Madam Chair was talking to Representative Scher, the idea of can and shall came up. She asked, can the judge refer it? Okay, this one says shall. Okay, if we're going to stop domestic violence, we've got to be tough on it. We can't be pussyfooting around with this stuff.
Thank you.
Representative Scher.
Just to further help this situation out, particularly in smaller circuit courts, where there's one judge who operates as the family court judge and operates as the circuit court judge hearing misdemeanors. The most common way that a domestic violence situation comes in front of the court is, in the first instance, when there's a domestic violence situation, the victim usually goes to the police, and then the police take it from there. The police may also refer her to support services who work with her to file a restraining order, domestic violence restraining order, or a protective order, or something like that. So it really depends on the court. All of it may be happening in front of the same judge, and the judge already knows that the police have, this came in front of the judge because the police chose not to file a charge or not file a charge, but they also advised her to file a motion for domestic violence protective order. So it's not as simple as, it's not very common that a person who's a victim of domestic violence appears in front of a family court judge and the police don't already know about the domestic violence. That's, I guess, what I'm saying.
And was that a would you believe for Mr. Love?
Would you believe?
Representative Love?
Yeah.
Thank you.
Would you believe? I know of a case that goes contrary to everything you just said.
Yeah, it happens. Yeah.
Okay, so seeing no further questions, thank you, Representative Love. I appreciate your time. The next person to be called will be Representative Joseph Barton.
Thank you, Madam Chair. Representative Joseph Barton, Grafton District 1. I apologize for not formally introducing myself on the previous bill. I'm going to speak quickly and briefly and what I believe the intent of this legislation is. So family courts are different than criminal courts in one specific aspect. They are courts of equity. They are not courts of common law. And what that means is there's no rules of evidence. So if you're being, if someone, and it's very easy to get, a domestic violence petition is filed, and then there's a court order. There's no due process for the individual, or either individual, really, to defend against it, because there's no rules of evidence in family court. That stuff ought to be processed through a court of common law. And I think that's what this corrects. You can actually have full due process. discovery, all of that stuff. That doesn't necessarily happen in family courts, and this I think would correct all of that, and it would put cases where there's actual criminality in the proper forum. That's all I have on testimony for this. I'm not going to take any questions. I expect you all to deliberate on those points when you exec the bill. Thank you.
Thank you. The next person I have a card for is Randy Collier.
Thank you.
Thank you, Chair. Representatives, let me speak on this bill. I support this bill. Seem to be a lot of fallacies and a lot of inconsistencies in the recent testimonies in the last few minutes.
Excuse me, you'll have 3 minutes.
Perfect. I won't need that much.
Thank you.
So correct, as Mr. Barton said, there is no rules of evidence in circuit court. And through the MOU, through the executive branch that pays the judicial branch referees to arrest us using the sheriffs when 490 F10 says that circuit court judges can't practice law in any degree. And then statute 493 A1A says all referees and marital masters must have a real judge sign off. So I've gotten 17 years of protective orders. General counsel testified last year, the year before, in one of these rooms that we automatically lose our rights in circuit court, but our rights are protected in criminal court. I guess the number one question would be, why do our rights evaporate at all? So circuit court's a presumption and assumption court and not a court of law, and evidence does not apply. So yeah, we need to pass this bill and get the criminal statutes that are used in civil court out, because that's treason and child abuse. Any questions?
Any questions? Seeing none, thank you for your concise information.
And I hope you all read my emails too. Thank you.
We do.
We do.
The next person I'm going to call is Lauren Warner. She's asked for 2 minutes, but I'm going to be kind and give her 3.
Thank you, Chair. I will hopefully even be briefer than 2 minutes. Good afternoon, honorable members of the committee. My name is Lauren Warner, and I serve as Deputy General Counsel for the Judicial Branch. The branch has not taken a position on the bill. I just wanted to note a few aspects based on my reading of the proposed legislation. This is applying specifically only to the family court. So we have the circuit court, which then has the family division as well as the district court. And as Representative Scherer has already addressed, criminal proceedings are handled by the district court as opposed to the family court. They have concurrent jurisdiction over some matters. So for example, a domestic violence matter may also touch on a divorce case, but the actual criminal aspect of that, the petition, the stalking petition or whatnot, would be filed in district court. So any criminal action related to that would be handled by district court. Yes, all circuit court judges, they can serve on both family and district court matters, but they would be separate matters. So as it is currently, the family division is a limited jurisdiction court that doesn't handle any criminal matters. So the only arguably criminal matter that could be considered in a family court case would be contempt of court. Otherwise, I would say where you have temporary orders for protection, criminal orders relating to child abuse and neglect and the like are following under the district court jurisdiction. So as 490 D2A is written now, it's related to the family division. These criminal matters aren't heard in the family division, but in the district court. And I do have written testimony I can provide. I already emailed it as well.
Oh, thank you very much. We'd appreciate your written testimony. Do we have questions? Representative Pearson.
Thank you, Madam Chairwoman. Thank you, Councilor. and I apologize, I was testifying before another committee, so I missed part of this. But if I hear you correctly, first of all, the judicial branch does not take an opinion about this bill because you don't take an opinion on any bill coming before us.
You are correct.
That is what you do. But here's my question. Given what you've just said, given what I know, the bill really tries to prevent something that already doesn't happen. Is that correct?
You are correct. The bill as it's written is related only to the family division's jurisdiction, and currently the family division does not have any jurisdiction over criminal matters outside of holding someone in contempt in a divorce case or a case that's in front of them. So arguably there would be none that could be transferred to Superior Court because those are handled by the district court.
Thank you.
Representative Raymond.
Thank you, Madam Chair. Thank you for taking my question. And thank you for coming to our committee today from the Judicial Branch. I just have a question about family court in general. The family court judges are actual judges, correct? Because they can serve in both criminal and family matters.
You are correct. So they are circuit court judges certified as such, and most every circuit court judge will sit on both a district court and a family division. There may be cases in larger courts where a circuit court judge might only sit over district cases and not necessarily sit over family court cases as well.
Thank you. Follow up, please. Follow up. Thank you. And regarding the rules of evidence that we've heard today, are there rules of evidence that apply in family court matters?
So it is Rule 1101, which requires rules of evidence to be followed. There is a carve out for the family court where they have the exception to waive rules of evidence as they see fit, but criminal matters fall under the district court. And the district court, the probate court, as well as all superior courts are required to follow all of the rules of evidence. So in this case, any criminal matters, there would be no waiver of a rule of evidence because the family division does not have that ability to hear those criminal matters. Those would be under the district court where the rules of evidence do apply.
Okay. Representative Love, did you have a question?
Thank you for taking my question. Would I be correct in saying that the difference between what we're saying here?
You're absolutely right. I apologize, Representative, you cannot. Thank you for reminding me.
You can write it down and ask someone else to ask it.
Yeah, somebody else can ask it for you. But Representative Nelson.
Thank you, Madam Chairwoman. Thank you for taking my question. Just for clarification purposes, rules of evidence for misdemeanor misdemeanor and felonies. Both courts systems follow the same rules of evidence, correct?
Correct.
Thank you. Representative Scher.
I will, for the record, point out that Ms. Warner had the misfortune of having an evidence class for me. So
Now she has to take a question.
This is a test. I might go back and
Open
review her exam. We've heard a lot over the past several weeks about the rules of evidence. Is it fair to say that the rules of evidence limit the amount of testimony that would be heard by a judge as compared to what would be heard by a judge when the rules didn't apply?
You are correct. Yes, it would limit what could be put in front of a judge as opposed to if the rules were allowed to be waived, more evidence would be allowed to be heard in front of a judge.
Correct answer. I won't go back and change the grade.
Thank you.
Thank you, Representative Pearson.
Thank you, Madam Chairwoman, and thank you again, Counselor. We often have heard the phrase in this committee, oh, they don't follow the rules of evidence. It is my experience that that is not what the case is. There is an allowance for perhaps setting a few of them aside from time to time, but I sat through several hours of court cases where I saw rules of evidence applied. Would that be a correct assumption on my part?
You are correct, Representative, and I apologize if what I said was misunderstood. So essentially, in family division, they are allowed to waive the rules of evidence, meaning they are allowed to bring in, as Representative Scherer asked, additional evidence. So say something that would arguably be considered hearsay and excluded in a criminal matter, but could likely be important in a divorce matter, they're allowing parties to provide additional information. So
Follow-up, Representative?
Thank you. So for example, it does not necessarily have to be probative to be allowed in.
you are correct,
Thank you.
Representative.
Representative Corzine?
Thank you, Madam Chair. Thank you for being here to answer my questions. With that extra leeway within the family courts, though, I hear many parents complaining that they're not allowed to introduce exculpatory evidence that could help them get their children back. This is one of my issues. I just heard from two people this week where they wanted to bring something before the judge and the judge would not let them add it. So I'm all for allowing for extra evidence to be added in, but when we start taking away a parent's rights to try to prove that they're innocent, I think there may be an issue. Am I correct in how I'm reading that?
I would say, so it allows for, in family division, for that waiver of rules of evidence, it allows the judge to determine it in a case-by-case matter. So I couldn't necessarily say what that judge did. I wasn't there, but that is always a possibility that if there was evidence presented that would violate the rules of evidence, that judge could say, or I'm following the rules of evidence in this matter, I'm not going to waive the rules.
I will take one more question. We'll do Representative Georges because you've already asked some.
Thank you, Madam
And-
Chair. Thank you for
Yeah.
taking my question. I think so. Everybody go too much with the rule of evidence, and you say case by case. That where is the problem, because there is a lot of people. They go with they bring those evidence. The judges doesn't take it, and she chooses who she can take it. That's where is the problem. I myself, I'm been there for my divorce. I'm already a witness. That's why, because the judge didn't want to take to my evidence.
And your question
that's where
is?
the problem. I think so. If there is a way how you can fix it up. Thank you.
What is your question?
My question was just for the rule of evidence, because there are people just complain about the rule of evidence, and myself, I'm the witness too, because it said the judge take it case by case. But now, what people can do to make sure they took those rule of evidence for each person, not choosing.
Do you choose to answer that? Do you even understand?
I apologize, I might not understand the question. I would just say
That's okay.
the rules of evidence apply, it's just that family division has the ability to waive in matters if the judge so chooses, but.
I'm going to ask everybody to hold their questions for a second because I'm going to have to recess this hearing at this time. I'm going to have to open House Bill 1770 and put it in recess. And now we'll reopen 1687, finish up with questions. Representative Scherer.
So we've heard not only here, but in this hearing, but in prior hearings about the issue of exculpatory evidence. And there will be a question to this, but there's a little background. So there's two things about exculpatory evidence. One, the right for the prosecution to provide exculpatory evidence to you, and you're familiar with that.
Yes.
And that only applies, and that's a constitutional right. And that only applies in criminal cases, right?
Correct.
And then the right to present exculpatory evidence may or may not be a constitutional right. Is that a fair way to put it?
You're talking about in non-criminal?
In non-criminal cases.
Correct, in non-criminal cases.
And in criminal cases.
Follow-up?
Follow-up, I'm sorry. In criminal cases, once I get going, I forget the follow-up thing. But in criminal cases, there is a constitutional right to present all proofs favorable. Is that correct?
Correct.
And again, that's just in criminal cases?
Yes.
Thank you.
Thank you. One more question and then we're going to move on. Representative Pearson.
Thank you, Madam Chairwoman, and thank you, Councilor, for taking this. You're new to the job. Were you there when the conversation with presiding Judge Christo was held with some of us who have been working on family court for a long time, to the effect that there would be, especially for new judges who do not come out of a family law background, more education, so that therefore some of the possible misuses of when not to do the rules of evidence take place? I think there's a question in there. Oh yeah, were you there when?
I was not there, but I think I have been able to speak with Judge Christo, and I understand that New Hampshire provides even more training to its family court judges than a number of other states. So they go through a great deal of training.
Follow up, and that more is on the way?
Correct,
Thank
yes.
you.
Thank you. Thank you very much. I have one final pink card for Shirley Harianto. And I will not accept any more cards on this because we're over time. I'll take one more. Shirley, you can take your seat and you'll have 3 minutes.
Sorry. Okay, my name is Shirley Harianto. I'm a single mom. I've been sit here for a few times already. I support the bills of
1687.
Yes, 1687. Thank you, Chairwoman. I appreciate it. I do not agree with the lady that speak earlier. One of the question has not answered correctly, even though I have a little bit, like I know that my English is not fluently, but I still kind of pick it up. But anyhow, I want to speak that I have an open case of a family matter, and they mention it that the evidence has to be provided or whatsoever, but so far all the evidence I have not been asked.
Okay.
And also any criminal, doesn't matter criminal or family matter, has to be investigated truly and carefully. I don't agree that everyone get treated unfairly, even though my position doesn't have any spouse or have not been married.
So you have to talk about the bill.
Yes. So
Madam.
So I want it to be the district court to not take fully power on a criminal matter, because I believe family and criminal is totally different thing. And I don't agree. They have to be separate between family and criminal.
Thank you.
You're welcome. I'm sorry if I.
That's okay. Any questions? Seeing none, thank you very much.
Yeah, you're welcome.
Final card is for Donald Gilbert. You asked for 2 minutes.
Thank you, Chairman DeSimone and members of this committee. I will try to make it briefly. I wanted to first follow up with a would you know kind of statement here is the fact that all domestic violence, child abuse, and criminal sexual assault and DV is actually a crime. If you look at the domestic violence statute 173B, you look at all the definitions under abuse, it outlines that a act of commission or attempted commission of a set guidelines of abuse must occur. Under 21M, you must be, again, an act or attempted act of a commission of a crime for a victim. Again, under 169C, again, there's a necessary implication, sexual assault, physical injury. Those are all crimes that need to be prosecuted as such. Moving on to the underlying aspect of the judicial training. If my memory serves me correct, and maybe somebody on this board committee can represent that a little bit better,
There was a legislative effort to provide psychological maltreatment. I believe it was in 2021 per for this committee, and that was contracted out to the Domestic Violence Coalition. To all my belief in intent to knowledge, that training never occurred. So that's for DCYF, law enforcement, and these judges were supposed to receive psychological maltreatment training that never occurred. The rules of evidence on this, and I think what was trying to be said by a couple of different people is, and Representative Georges is how do we oversee which judges may be using it more leniently or being more combative against certain individuals in a litigated case. And I think that might have been what was trying to be said by a couple of these individuals, is that there is specifics that outline that there might be some impartiality going on, specifically with the woman that just testified before me. The other litigant in the case is a judge, a sitting judge. So there's some impartiality going on. Yeah, I think the bill seeks to the intent of, separating that. The family court judges are supposed to be doing family law. They're not supposed to be issuing the criminal orders. Yes, they are circuit court judges. I understand that. They should be acting on the family law, but thank you.
Thank you. Any questions for Mr. Gilbert? Seeing none, thank you very much.
Thank you very much for having me.
With that, I will close the hearing on House Bill 1687. I will bring the hearing of House Bill 1770 out of recess, and we will invite Representative I'm waiting for him to get there. Chabon Deschonnet.
Pardon me, French.
Thank you, Chairman DeSimone. Thank you, members of the committee. And it's always great to see my colleague from Criminal Justice, Representative Scheer.
Good to see you.
Thank you, sir. Introducing HB 1770 today, relative to the allocation of parental rights and responsibilities and establishing a presumption of equal parenting time. Being passed out is written testimony from the national chair of the National Parenting Organization. He's got some science to share with us regarding the benefits of equal parenting time for children, how equal parenting time helps reduce anxiety in both parents and children when it comes to divorce proceedings, and it results in less trauma and therefore a better experience for everyone. Our current bill is approximately equal parenting time. That's the law right now, and it grants courts and parents the widest discretion in developing a parenting plan. What this bill does is it creates it defines equal parenting as a 50-50 overnight split with limited deviation, and it provides a constitutional presumption of equal parenting time. Nothing in this bill supersedes any domestic violence statute that's on the books, and nothing in this bill shall interfere with a plan that is already agreed upon by the parents that is consensual for their own plan. The current law does enable parents to make their own plans, but the way that this bill would change things, that if you do go to court, the presumption should be 50-50. I should note that actually just today, South Dakota Senate passed their own equal parenting time bill under their SB 224. So we're not alone in this effort. And I know that as of 2023, there was an 86% support in New Hampshire for rebuttal presumption for shared parenting being the best interest of a child after parental separation. And then as of last year, 2025, per NPO, that has moved up to 90%. So this is a popular idea. Please support the OTP motion on this bill. I have lots of other folks testify in support today. I'll take any questions to the best of my ability.
Representative Raymond.
Thank you, Madam Chair. Thank you for taking my question. I have a couple of technical questions about the bill. The first one is on line 6, line 11, line 15, on page 1, where it says there should be a constitutional presumption. My question is, why is this not a CR if we are trying to change constitutional protections in the state?
We're just approaching this as a bill, ma'am.
Okay. Follow up. Follow up. Thank you. My second question is about line 15 and line 24. Where it says parents are presumed fit unless proven unfit by clear and convincing evidence of harm. Are you aware that the criteria for evidentiary criteria for making a finding of child abuse or child neglect or child sexual abuse is a preponderance of the evidence, and clear and convincing is the threshold for terminating a parent's rights? So if we change the law to say clear and convincing evidence here, that a parent with a finding of abuse, for example, someone who has repeatedly burned their child with cigarettes, would be considered fit even though they have that finding?
That's a good question. I'll let some of the representatives from MPO to answer that for you.
Thank you.
Representative Gregg.
Thank you, Madam Chair, and thank you for taking my question. What specific constitutional provision creates a constitutional presumption of equal parenting time? I have not seen anywhere where New Hampshire Constitution mentions parenting rights.
I think that that's just inherent in nature. I think that's a child has a mother and a father, and it's in the best interest that they get to experience time with them if they are separated equally to best aid in the emotional and psychological development of the child.
Okay, so this is follow up.
Follow up.
Thank you. So this is your presumption, not an actual constitutional presumption that's in our Constitution.
I think it's very reasonable, 50-50 presumption. I think it's a reasonable presumption.
Thank you.
Representative Levesque.
Thank you, Madam Chair, and thank you for taking my question. When it comes to the 50-50 parenting time, especially with the overnights, what if some of the parents want to move closer to their job? Like say they were living here in New Hampshire and they work in Massachusetts, like a lot of our constituents do. What happens if they decide, oh, since I don't have any obligation here, I can move down closer to my job, and then they can't take their kid overnight because the way that their living situation is, they can't do that. What would be the determining of that?
I'll have to get back to you on that answer, ma'am.
Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. I know you're going through for equal parenting time. This is for the best interest of the children or the best interest of the parents?
I think it's in the best interest of everybody.
Follow up.
Follow up.
Thank you, Madam Chair. Because we are here for the best interest of the children.
Mm-hmm.
For the best interest of the children, I know we need to look to who's the person who are really available with the children, not just because for all of us. Because it can be the parents, sometimes because for the child support, because they don't want to give you the money. But if we're ready for the children, do you think you think about the person who can have more time with the children, or just 50-50 because it just is for both?
So the way that this starts is that if you go to court, the default presumption is 50-50, and then also includes presumptions. Orders granting less than 50-50 equal parenting on the last page, guys, shall have a judicial officer pursuant to Part 2, Articles 72A and 73 of the New Hampshire Constitution review and sign all orders ensuring the correct constitutional protections have been applied. So there is room for, if you're doing less than 50-50, there's a way to do it.
Follow up.
Thank you, Madam Chair. Because I'm here for the interest of the children. My problem is, do you know sometimes a father can have another woman, a woman or girlfriend or wife, but that woman cannot take care of really the children for another one, and the children go over there, there is a problem. Do you guys know about that?
I think you brought that. It's a good point.
That is my point, because this is the problem we are here for the children, especially when they're too young, when the children are young. When they are becoming the old, it's okay. But the young, we need to look for interests of the children.
Thank you. Representative Love.
Thank you, Madam Chair. Thanks for taking my question. Are you aware of studies that show that children do best with both parents, and that there's, I'll let you answer that one first.
Yes, and we actually handed out written testimony from the chair of National Parenting Organization that illustrates a few of that. So, yes.
Follow up.
And are you also aware of the statistics that show that high school dropouts, teen pregnancy, drug abuse, alcohol abuse, a whole litany of things happen when one parent is missing?
Absolutely. Yep.
Thank you.
Representative Gregg.
Thank you, Madam Chair. So tell me, compare the two right now. We have a presumption of, what is the exact wording of our bill or statute that we currently have?
So Representative Gregg, right now the wording, and actually the way that this
Because we
bill-
just passed it. So.
Yeah, the bill that's written is actually it changes, it shows point by point. So right now, the current law
Approximately equal parenting time.
Encourage approximately equal parenting time between each child and both parents.
So approximately equal is what? If 100% is approximate, what's approximately equal?
So that's what this bill is clarifying. So we're going to move from approximately equal to specifically say that each parent receives 50% of annual overnight. So it's a new presumption of 50-50 specifically, as opposed to approximately equal. So we're allowing some quantification into what is already qualified.
Did you happen to look at, because we just passed this bill a couple of years ago, did you happen to look at what the committee talked about and some of these nuances as to why the wording is a little bit different?
A little bit, yeah.
You didn't, did you look at
I did.
our committee?
A brief-
Okay, thanks.
Yeah.
Representative Raymond.
Thank you, Madam Chair. I'm sorry, I have one other question on the wording. I noticed that throughout this statute, you have crossed out the best interest of the child in every instance where it appears in the statute. Are you aware that we would be the only state or U.S. territory that no longer considers the best interest of the child?
Well, we are quantifying that, and then again, South Dakota actually passed out of their Senate today SB 224, similar legislation. So we're not.
I'm sorry. Can I clarify? The South Dakota legislation eliminates the best interest of the child as the standard.
Their standard is 50-50. Yes.
So is ours. Ours is 50-50.
Well, it says approximately.
I see. Did the South Dakota statute remove? I'm sorry. Thank you. To clarify, did the South Dakota statute remove the words "the best interest of the child" in every instance where it showed up in their statutes?
I believe so.
Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my call. I looked at, I do it every time. I'm so sorry. I'm sorry.
Long time
My
caller.
answer, my question. Okay, a reset. I'm looking, thank you for taking my question, and I'm sorry about my legally blonde moment. I'm looking at Senate Bill 224 that you were referencing, and it does, to the best of my knowledge, it doesn't say 50-50. It says reasonably equal, approximately and reasonably equal for each parent as agreed upon by each parent or as ordered by the court. So that's what we presently have.
Yeah.
So is there another bill that you meant to refer to?
No, I might have been mistaken though.
Okay, thank you.
Thank you.
Representative Scher.
Thank you, Madam Chair, and thank you for taking my question and for your testimony. I want to look at the second page, lines 14 through 17, that say orders granting less than 50-50 equal child parenting shall have a judicial officer pursuant to Part 2, Article 72A and 73A of the New Hampshire Constitution. Let me ask a question about that. Is it your understanding that a family court judge, who's a circuit court judge, is a judicial officer, is a constitutional judge?
I'll have to get back to you on that.
And follow up?
Follow up?
And then the last part of that, review and sign all orders ensuring the correct constitutional protections have been applied. What, to a very general reference, what are the constitutional protections that this refers to?
I'll have to get back to you on it later as well.
Thank you.
Thank you. Seeing no more questions, thank you very much, Representative.
Thanks, guys.
I'll next call Lauren Warner. She has no position on the bill, but has asked for 2 minutes to speak.
Thank you, Honorable Committee. My name is Lauren Warner. I again serve as the Deputy General Counsel for the Judicial Branch. I do have written testimony. I will pass that out thereafter. I just wanted to make one notation regarding this bill. As written, it would convert a statutory preference now into a constitutional right, which has been brought up just previously by some of the questions from the committee, arguably creating a constitutional right outside of the ability to amend the Constitution likely would then be found unconstitutional. So written as a bill, not a CACR, would not be necessarily the appropriate path to take to make such a constitutional right. That's all I wanted to note.
Thank you. Seeing no questions, I appreciate your time and your expertise.
Thank you.
Next, I'll call on Mary Kruger.
Thank you, Madam Chair and members of the committee. My name is Mary Kruger. I'm with New Hampshire Legal Assistance. We're a statewide nonprofit law firm providing civil legal services to low-income clients to help them meet their basic needs. I direct our domestic violence advocacy project, and I've been doing this for close to 20 years. We are here to oppose HB 1770. Mainly, this would make 50-50 parenting mandatory unless there are grounds for terminating parental rights. That would totally eliminate the ability for a court to look at the best interest of the child standard. You'd be wiping out that standard that exists currently under RSA 461A6 and the several factors in that that the courts currently consider to determine what is in a child's best interest, including whether there's been child abuse or domestic violence. And in cases where victims understand this to be the law, they could be very concerned to decide to leave an abusive relationship because they may be in fear that their children could continue to be abused and exposed to violence when they're not present anymore in the home. Because this 50-50 parenting burden is so high. Clear and convincing evidence is an unusual standard to apply in civil context. It may apply in certain civil contexts, but it's fairly rare. And pointing to the termination of parental rights standards really narrows the ability for a court to make protective orders in cases where there's been domestic violence and child abuse. I think victims will end up staying in these situations, feeling that they have no choice, so that they can continue to protect their children. We already have a law that allows for approximately equal parenting time. We just passed that a couple of years ago, and that is the policy that we currently have. So this really is only meant to make it more restrictive and more difficult. Lastly, I'll say that I'm not sure how to interpret some of the practical aspects of this law. In section D, it talks about
30 seconds.
How to apply those exceptions to 50-50, which I think would be difficult to implement. And finally, it does not appear to allow for parents to make agreements. So we are asking this committee to vote inexpedient to legislate. Thank you.
Thank you. Do you have written testimony that you can submit to us?
I will get that to you, yes.
Please, thank you very much.
Yes.
Any questions? Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. I'm looking on section F, so on page 2, line 5. This section applies to original suits, temporary orders, and suits for modification under this chapter. Does this mean all suits retroactively?
This means people can go back to court and change their orders based on the new law.
Thank you. Representative Raymond.
Thank you, Madam Chair, and thank you for taking my question. As you're reading this, you had said something about parents making their own arrangements. Would this stop the 85% of families that make their own agreements from being able to do that based on their own personal family situation and children's needs?
It appears to do that. It strikes the current language where it says grant parents and courts the widest discretion in developing a parenting plan. So that would prevent parents from developing a parenting plan, and that the presumption is only rebutted under the circumstances that are listed in this section.
So follow-up question?
Follow-up?
So if we have parents who, based on their own circumstances, I'm thinking of a friend of my daughter's who's a competitive swimmer. She spends most of the time at her dad's house because his job allows him to drive her to her swimming meets, whereas the mother's job does not. Would that prevent them from having the flexibility to make that arrangement and force them into a 50-50 situation?
That's what I see in this language, and I think it also speaks to that it would be very difficult for someone who needs to relocate for safety as well.
Okay. Thank you.
Representative Corzine.
Thank you, Madam Chair, and thank you for being here to answer questions. I think along the same lines as you, although I love the bill, I love the 50-50 parenting time, because in a perfect world, when you have two healthy parents and they both have a relationship with the child, that's in the best interest. My fear, though, is how a court could distinguish between patterns of coercive control or that type of domestic abuse. Does this bill spell that out at all to protect those victims?
This bill would not allow the court to consider coercive control because that's not part of the definition of what the exception would include. If you look at termination of parental rights, there's nothing about coercive control. You have to look at the definition of the grounds for termination of parental rights in order to meet an exception. So I have, a copy of that if the committee wants to take a look at it, but most of the grounds really make more sense in the context of where there's been a child abuse and neglect case that's already been determined, and now termination is on the table, and there's a new case. And so a lot of this has to do with that system itself, although you can bring an individual petition to terminate without a child abuse and neglect case. But the grounds themselves don't provide for that sort of broader, coercive control, or whether it's sort of like psychological abuse or emotional abuse that could happen to the child or to the other parent or both. So it really limits and narrows the exceptions to that strict 50-50, whereas we currently have the policy of the state is approximately equal parenting time. And so that's already what we put into law just a couple of years ago. So we're still sort of navigating that. That's like a brand new standard that the courts are now applying. We haven't even been able to see how that's going to work, mechanically and for families in New Hampshire.
Thank you. Representative Scher.
Thank you, Madam Chair. And again, thank you for your testimony and taking this question. I'm looking at page 2, the lines 14 through 17, which, putting aside the judicial officer piece, orders granting less than 50-50 equal shared parenting, the judge has to review and sign all orders, ensuring the correct constitutional protections have been applied. Are you aware of any constitutional protections that apply to a child custody situation?
So in New Hampshire, the New Hampshire Constitution does provide that parents there are parenting rights. The right to parent, sorry, I'm not saying it correctly, but the right to parent is a constitutional right in New Hampshire. However, that has, like every other constitutional right, sort of its limits, right? So I think what this is trying to do is really apply the limit of a fit parent, whether somebody's a fit parent or not a fit parent. We don't do that right now under law. And a fit parent meaning if you're not a fit parent, then potentially you would have your rights terminated. But we don't terminate rights in the context of RSA 461A. So we're sort of importing these other concepts from a stricter adherence to termination of parental rights we're importing that concept into a best interest standard. So we're making the best interest standard to be the standard for terminating parental rights is one way to look at it if this law were to be adopted.
Thank you.
Representative Georges.
Thank you, Madam Chair. I just thank you for taking my question. It's not just, I want to just to clarify a little bit. For the best interest for, like he said, for both the children, the parent, and everybody. For you, for the best interest for this, it's going to be for the children, because I can give example for myself. My daughter went to the parent but she didn't want to go, but I let her go. But when it came back, she was sick, and almost a week never back to school. When you go to the counseling, she told the counseling, I told my mom I didn't want to go to my dad to sleep over there, but my mom let me go. The counseling just make me start to talk to me now. I don't supposed to do that. I need to hear what the child said. Now, for the best interest of the child, or best interest of all of us, what do you think is the best?
Well, I can tell you what the current law and the policy of that law is, which at New Hampshire Legal Assistance we would support, which is that there is a best interest standard that applies under RSA 461A6, where it's looking at what is in the child's best interest. So that is the primary concern that we currently have. But we do call our law parental rights and responsibilities. So there's this acknowledgement, and like I just said, parents have rights. It's a constitutional right to parent, right? So you do have this kind of convergence of those concepts. And where, again, where those rights sort of begin and end have to do with, okay, what is the impact on a child, right? If we're going to terminate a parent's rights, we have to show that they're not a fit parent. And that's a high standard, and it should be. And that means that something very bad could happen or has happened to that child where they've been harmed. When we talk about parental rights and responsibilities in the context of family court, we have a whole list of factors that the court can apply to again, support approximately equal parenting time. We used to have frequent and continuing contact as in the best interest. That sort of the idea that we fully recognize that children do best when they have both parents in their lives. But that can look very different depending on the family's individual needs, the skills of the parents, the ability to meet the developmental needs of a child. And all of those things are reflected in RSA 461A6, where the court is going to look at those things, the relationship of the child with the parents' relationship with one another, the developmental needs of the child, whether there's been domestic violence or child abuse, whether it's safe, the kind of contact that a child ought to have with either parent. All of those factors in 461A6 are sort of a balancing act that the court can do to make sure that the child is going to be safe and able to thrive and to have that safe contact with both parents, so that they can, grow and thrive.
Thank you. Any further questions? Seeing none, thank you very much.
Thank you.
Next, I'm going to call Representative Joseph Barton. You've asked for 2 minutes.
Thank you, Madam Chair. I will be quick because I'm not going to take any questions. So I wanted to follow up on some of the craziness I heard earlier. One is the constitutional presumption.
Excuse me, sir. We don't refer to craziness here. That's disrespectful.
Okay.
Thank you.
In line 6 where it says there shall be a constitutional presumption, that's not seeking to change anything in the Constitution, either our federal Constitution or our state Constitution. It's presuming that it's already there, and it is already there. It's in the 14th Amendment, which is the Due Process and Equal Protection Clause, and in Part 1, Article 2 of our New Hampshire Constitution, referring to natural rights. So that presumption is what that line refers to. This is not seeking to change anything in our Constitution, certainly not the federal Constitution. The other thing that's addressed is abuse and neglect in lines 26 through 29. If there are certain standards, this addresses that. What this does is it makes 50-50 a starting point. And my daughter, if she were here to testify, she's 8 years old, she would love to spend half of the time with her father. She only gets about 40%. What the best interest standard that's spoken about in the statute, all that says is a judge is supposed to write the findings in the final order. They never do that. They just say the court finds X, Y, and Z. And it could be, it's in the financial best interest of the child because parent A doesn't make any money and parent B has to subsidize for that. So we're going to take less parenting time and do the child support formula so that way they get more money with this parent, but they get less time. And that's not fair to the child at all. Like I said, and you can watch my testimony on House Resolution 45 where my daughter came in. You'll see that time is more important than money. And study after study shows that equal time with both parents, especially as they get older, is more conducive to the child's upbringing. And that concludes my testimony.
Thank you.
Thank you.
Thank you for coming and testifying again. Next, I'll call Gail Drobat. You'll have the 3 minutes you asked for. Yep.
What's red?
There you go.
Oh, sorry. Thanks. Madam Chair, members of the committee, I rise in support of HB 1770, establishing constitutional presumption of equal parenting time. This amendment modernizes 461A by aligning the New Hampshire family law with constitutional principles in child development research. It replaces open-ended judicial discretion with a clear presumption of equal parenting time, recognizing that children thrive when both parents remain fully and meaningfully involved in their lives. The bill properly restores the constitutional presumption of parental fitness, requiring that states to meet the strict scrutiny before limiting a fit parent's relationship with their child. Any deviation from equal parenting must now be supported by clear and convincing evidence or specific harm under RSA 170C5, ensuring that state intervention is based on actual risk, not subjective opinion. This framework protects children by promoting stability, continuity in care, and secures attachment to both parents while safeguarding families from unnecessary government intrusion. It ensures the parental rights are treated as fundamental liberties, not privileges subject to administrative discretion. This amendment is what is best for children. Decades of research has proven providing children equal access to both fit, willing, and able parents after separation of divorce allows better outcomes for children. Nothing in this amendment prevents any parent from making arrangements, parenting plans for their family's specific needs, work schedules, military duties, or to better meet their children's needs. This does not take away judicial discretion in domestic violence. If domestic violence exists, there are ample provisions throughout New Hampshire laws that ensure safety for children, fathers, and mothers alike if abuse has been clearly shown. HB 1770 is not radical, it is constitutionally correct. The United States Supreme Court has repeatedly held that parenting is a fundamental liberty interest and that the state may not interfere absent clear and convincing evidence of harm. New Hampshire's current system allows courts to reduce a fit parent's time based on subjective best interest opinions without strict scrutiny, without evidentiary standards, and without meaningful appellate review. This is not judicial discretion, this is unconstitutional power. HB 1770 restores the presumption of parental fitness. There is a presumption that fit parents act in the best interest of their children. Troxel v. Granville. Equal protection between parents you can find in the New Hampshire Constitution.
30 seconds.
Part 1, Article 1, Article 2, 2B, and 4. Due process for families and strict scrutiny when fundamental rights are restricted. Basically, this does not change our Constitution. Our rights come from our creators, and government has limited ability to restrict those. So by clear and convincing evidence is the best standard for children.
Thank you. Any questions? Seeing none, thank you very much. Next, I'll call on Emily Lawrence. After you introduce yourself, you'll have 3 minutes. Thank you.
Thank you. Good afternoon, Chairman and members of the Children and Family Law Committee. My name is Emily Lawrence, and I am the Advocacy Director with Waypoint. And I am here today to talk about some of the concerns that Waypoint has with the bill and to ask that you vote inexpedient to legislate. Just to begin, a little background on Waypoint. Waypoint's been serving individuals, children and families for over 175 years across the state and across the lifespan, so from birth to death. Our services include early support services, for families, therapeutic counseling, court-ordered in-home services for individuals that are involved with DCYF, and advocacy for vulnerable populations. We also operate 4 family resource centers. So I do have written testimony, and so I'm going to rely on that for the majority of our argument and concerns over this bill. And I also will say that some of the concerns were already discussed in the conversation with Attorney Kruger. Today, what I would like to do is really just focus on the best interest of the child. In our advocacy, we're always advocating to ensure that children's best interests are met. And this would really not only weaken that standard, but really it would entirely removes it from the bill. As you've already heard, every 50 states, as of last night, when I did my research, had the standard best interest of the child. We can certainly look at South Dakota to see that change, but this is something that is not unique to New Hampshire. And so what this bill would do would really shift the child-centered decision-making to parent-centered decision-making. We want to be clear that we support having as much time as possible with each parent. We understand that developmentally, this is the best thing for children, but there are times both when there is perhaps crisis or safety concerns, and also just practicalities when that can't happen. So equal time is not always the same as what's best for the child, and the children's interests must remain a priority. I just want to share a couple of the concerns about this bill that would really remove the flexibility judges need to look at these cases.
30 seconds.
We have staff that see all sorts of situations. So, for example, infants and toddlers, we know they need consistency and stable sleeping environments. Special needs children often struggle with frequent transitions, and young children form primary attachments that can't simply be split by the calendar. So, those are just a few examples of situations where it would be hard to have a set rule of equal parenting time. So thank you very much, and I am happy to take any questions, and we would ask that you vote in expedient to legislate.
Thank you. Any questions? Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. I'm curious, at the current time, are you aware if the courts take into consideration the child's expressed wishes? Like, is there a certain age or developmental stage where courts start listening to maybe adolescents or kids about how they feel about parenting time and where they want to be?
Thank you for the question, and that's a great question. Actually, when I was looking, doing some research on this bill last night, I did see several research articles on whether courts do look to that. What I saw is that it's right now it's discretionary, so a judge could certainly take into the child's expressed interest, and that can be part of the best interest factors, right? And we know from at least our work in the abuse and neglect world that judges will often try to get the adolescent's perspective on things. So I would imagine that that also happens, but I can share some of the research that I found on that too.
Thank you. We would enjoy that research.
Sure.
Thank you.
Mm-hmm.
Any further? Representative Pearson.
Thank you, Madam Chairman. Thank you, Councillor. Does your experience track with my 50 years of my day job, which said to me maybe 25% at most of families would do well for the children with a strict 50-50, and the rest of them would not do as well for the children with that? Does that track with your experience?
I mean, I can't give a percentage, but I can say that certainly what we've seen in the cases that we have is that I can't think of one where 50-50 would be completely workable. And most of those families agree to that.
Thank you.
Thank you. Seeing no further questions, thank you very much.
Thank you.
The next card I have is Matthew Blyer. You've asked for 5 minutes. I will give you 3 minutes. Oh, and do you have your written testimony, madam? Turn your mic on.
There we
Thank
go.
you.
Hi guys, thank you so much. How are you? All right, so it's my understanding about this bill is that it's basically just a starting point. Right now we kind of start skewed. I kind of need to go backwards to go forwards and kind of give you a background. I filed for divorce December 9th, 2019 from an abusive partner. It probably took me about 3 or 4 years to gain up the courage because there was no bill like this in place. I was threatened if I ever filed for a divorce, she would keep my child. And it's basically come true. My daughter's missed 300 days of school. She's finally back in school. Multiple DCYF reports. Mom, she was going to lose custody 3 times. GAL recommended a removal from mom. And I'm still fighting for custody 6 years later. I basically see my daughter 1 or 3 hours a week, despite having a parenting plan, and it's still not being followed. Multiple contempts haven't been followed, granted, stuff like that. So I understand, you know, in talking with my new friends today, that the focus is completely on children. You know, I know everybody's going back and forth about parents, and it has nothing to do with that. The only reason I stayed with an abusive partner was because I wasn't sure. I thought she would keep my daughter, and it's happened. So we're starting at an unequal playing field from the get-go as of right now. And if we don't level the playing field, nothing in this bill is saying that you can't get to your first hearing and say, this is X, Y, and Z, why this parent should not have 50-50. But if we can start at an equal playing field where both parents are granted 50-50 from the get-go, it just only protects children, you know, and I don't know. I don't know what else to do. It's a good bill to help children and protect abuse victims and children. So, thank you.
You're very welcome. Any questions? Thank you for your testimony.
Yep.
Next, I'll call Shirley Harriet Into.
Thank you.
Thank you. After you introduce yourself, you'll have 3 minutes. Turn your mic back on. Red light means on.
Okay, thank you.
It's the opposite of what we think.
Oh, okay. Because red usually stop. Okay, sorry. I think white is go. Okay, thank you, Chairwoman Simone. I support the bills of. No, I forgot where's the bill. Okay, yeah. My name is Shirley Haryanto. I'm a single mother of an open case with DCYF. I speak in the behalf of myself and others. So I know that I'm not speak right fully, but I'm gonna speak very shortly that I write it down here. Parenting time should be directly, purely, fully equal unless have definite evidence of child abuse with careful investigated without fabricating of any means and any party that connected or any connection with any conflict of interest. Many judges, and especially DCF or DCYF, they kept using reasoning of the best interest of children by manipulating courts and results. Courts should not have control of parenting rights in any means from district court as giving unfair judge or force or coerce or a gaslighting. Parents should be given by solid 50% and 50% as focusing of children's best interest of creating good children with a good mental, good behavior, as polite as creating better future for children. I study parenting as for genetics and science of parenting, as well as I receive any certification. I disagree to not have both parents to not equally have equal times for good for of the children. Where is it again? They should not limit it of parenting time percentage based to not fully finding of parent being unfit. Not taking parenting time just because of money base or income or any other formulas that they use, especially for people that doesn't have any legal background and use it by party or any other parent or judicial official that treat children as objective of their own beneficial of judicial jurisdiction from many people who is their belief. Children advocacy supposed to not have hidden interests with hidden agenda, as what happening on my case that my son was being abused by foster parent and DCYF or parent aid or third party, including judge, didn't take seriously concern and keep blowing me off. As example, as a single mom, I didn't get much time with my child over my case from the beginning of the case.
Madam, you have to stick to the bill, please.
Oh, okay. So
And you have
anyhow,
30 seconds.
So I want the children to have 50-50 equally from father and mother because I believe their mentally behavior and everything is connected to each other as my I study from the college degree. So somehow if the parent time one or the other less, then their behavior is also affected to become negativity instead positivity. That's thank you. I think that's it.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
The next card I have is for Donald Gilbert. Did we get the book? That's from Waypoint, she said.
Thank you, Chairman DeSimone and members of this committee. I think there's a little confusion between both some committee members and some of the general public that testified. 170C already has a beyond the reasonable doubt evidence standard. So this actually lessens the burden proof under that to clear and convincing. For that reason, I do believe that this might need an amendment or a interim study just because I don't think that was an intended mechanism to potentially go ahead and move 170C to a lesser burden, stripping further due process from individuals. But nevertheless, under the 14th Amendment, it already is a constitutional protection to raise your children. It does not classify equal parenting, but that should be the presumption. If there is the best interest of the child, should be presumed that every parent is acting on the benefit of their child. That's the starting ground. That's where the starting ground should be. It's not saying that you can't deviate from that. It's not saying that somebody could have 60 and 40 or present evidence that there was abuse or neglect that was founded in a court that could go ahead and say, hey, this parent shouldn't have this child at all until XYZ is remedied under those statutes. Myself specifically, I know it's been a little bit, but I was one of those parents where I wanted 50-50. This is back in 2011, so I know the statute is a little outdated at this point, but we wanted 50-50 and the court wouldn't allow us to have 50-50. They mandated us to have a split time. The mother and myself agreed for 50-50 and the court at that time wanted it to be deviated and said that it couldn't be 50-50 exactly. Learning now over the years, it does fall into line because of child support statutes that require some deviation, that, you know, there's an MOU with DHHS between the Family Division and DHHS for child support orders that require to act in the best light of the state when issuing parenting plans and child support. So yeah, we're starting off with the 50-50. Just as a reflection to Representative Corzine, coercive control would technically, Representative Schur can correct me, but would follow under the abuse and neglect statute under psychological maltreatment and emotional distress, based off the language in that. So yeah, I think, you know, this is a good starting point to solidify that, you know, the starting point is 50-50.
Thank you. Representative Scher.
Very briefly, you referenced the standard in 170C, beyond a reasonable doubt. That 170C relates to termination of parental rights. Is that correct?
That is correct, and it is a language that was used in this bill. I don't know why or the underlying reason of why it was used in this bill, but it was language that was used in this bill on the front page.
This bill, follow-up.
Follow-up?
This bill doesn't relate to termination of parental rights. It relates to child custody, correct?
That is correct.
Thank you.
Thank you, and thank you so much for your testimony.
Thank you very much.
Oh, I'm sorry. Do you take another question?
Yes.
Thank you. Representative Love.
Thank you for taking my question. Thank you, Madam Chair. Did I hear you correctly when you said the child support statutes take into consideration the best interest of the state?
The MOU does. There's a contract between DHHS and the family division courts to order issues in the best interest, the best light of the state.
Wow, thank you.
Thank you, Madam Chairman, and thank you for taking my.
Representative Nelson.
Oh, I'm sorry. I thought you were tired. I'm sorry. Where would I find that MOU?
So that MOU is under the Executive Council. I don't remember what last year issue it was. I believe it might have been 2024 or 2025 was the last issue date. But I can definitely go ahead and send that to this committee if you'd like.
Thank you. Thank you. If you could email us, that would be great. Thanks.
Not a problem. Thank you.
Greatly appreciated. Any other questions?
I'm sorry,
Don't. Thank you very much for your time.
Thank
and
you very much.
information. The next card I have is for Randy Collier.
Oh, I'm sorry.
Okay.
Thank you, Madam Chair, Randy Collier. Thank you, rest of the chair, for letting me talk on this bill. I support this bill. There's been a lot of things said. Try and go over right quick. There should never be anything but the highest presumption of innocence in order to take a kid away. You should never shift the burden of proof to anything, especially kids. It's unconstitutional. Chairman Lynn directly contradicted Gardner about the presumption of.
This bill is not about taking children away. This is about 50-50.
Well, if it's not 50-50, then you're taking the kids away. So that's why we're talking. No?
You have to stay on the subject matter of the bill, please, sir.
Right, I was. I was kind of doing
Okay,
the backstory as everybody else has done.
Thank you.
Okay. So because there isn't a presumption in family court because of the two different contradicting testimonies from the referees and Supreme Court justice, you can't shift the burden of proof. I don't know. There's been so much said that I don't even know where to go now. Yeah, I support the bill. Highest burden of proof. And I'm just curious if circuit court is paid by the executive branch on the MOU for the referees to arrest us, which is the parenting plan and best interest of the kids. I'm wondering, is it at any time the best interest of the child to put criminal statute protective orders against the parent without evidence in civil litigation?
Do you have more testimony, sir?
Not at this time.
Okay. Any questions? Seeing none, thank you very much. The final card I have is for Dana Albrecht.
Thank you.
Good afternoon, Mr. Albrecht. You have 3 minutes.
Good afternoon, Madam Chair. I'll try to be brief, as difficult as that is. This bill is about hurt. It's about the hurt caused to children in a contentious divorce. And we as parents focus on the pain. Maybe we should focus on forgiveness and solutions. It was said earlier, someone asked earlier what children think about this. Well, I'm passing out an email from my adult son, what he thinks about this. I won't read it to you, but I ask that you read it. With that said, I'd like to address just a few things I heard earlier. What I believe is conflicting testimony from the representative from the judicial branch that somehow this isn't in the Constitution. and testimony of a long history of case law where it is State v. Robert H., 1978, Nelson and Horsley, 2003, Kurowski v. Kurowski, again, State Supreme Court, already has a presumption that parents are fit, as does Troxel v. Granville under the 14th Amendment. That tradition dates all the way back to Locke's Second Treatise of Government from 1689. I sent a copy out. The title's misleading. It says on paternal power, but it's really about equal rights and responsibilities for parents. He uses the word duty, and I think we spent too much time talking about rights. Let's talk about responsibilities, or in Locke's language, duty. I had the duty to care for my children, stripped by the state, a de facto termination of parental rights. And so I respectfully disagree that this bill, is not about the termination of parental rights, because my parental duties were terminated. And my younger son talks about that. I ask that you read that, and I'll try to close because I'm a father. I have 2 sons, and my oldest, through 10 years of contention in my family, has lived with me. He has been of service to me. And my younger son was sent by this state, to faraway states and countries. He wants to come home. This state prevented him from coming home. This state prevented my duty to care for him and treat him properly so he could come home. And I've heard we've already solved this, which HB 185, yet we heard a father here in a current case where that's not being applied. And I just have to ask why. And in closing, I think we can go through a lot of time. The feelings disappear, but we're still hurting, and this problem is still not solved. And so please listen to me. Please listen to what my younger son has to say as an adult in his email to me. And if this bill has some technical drafting flaws, and I believe it does, those are, parents should be able to reach agreement, all of that. The remedy for that is an amendment, not to throw the idea out. And I guess, last but not least, you have a philosophical basis for passing this from John Locke, and you have a modern quantitative basis for passing this from the National Parents Associations. And those both strongly support the principles here. And if there are technical drafting issues that don't implement these principles properly, the remedy is an amendment. Thank you for your time.
Thank you. Any questions? Seeing none, thank you very much for your testimony.
Thank you.
I do not have any further pink cards, so therefore I will close the hearing on House Bill 1770. I thank everybody for their testimony and the time they took to come.
Thank you.